Sorry for the delay. We were with the members of the bar this morning because there's a new canteen and the long pending demand of the bar. You know, there was no canteen in the ABC complex, the additional building complex.
I just wish to point out to your lordship that I have filed that written submission additional. It is in volume 8 at pages 28 to 30. Just your lordship may note where the judgments are concerned.
Volume 8.
Volume 8, page 28 to 30.
Yeah. Thank you, Mr. Patel.
My lords, yesterday when my lords had risen, I had finished point 6. Your lordships have my note. It's 2C now. Volume 2C. It's been uploaded. So, yes, 2C. My lord, the Chief Justice has 2C.
Yes.
Mr. Kumar. Point 6, I had concluded by showing your lordship that section 14(2) of the Lokpal Act, which reproduces effectively the section 105 and its import. So whatever is the interpretation that your lordships give here will have an impact there as well. Sorry, my lords have it?
No,
Volume 2C?
It's not there. All right, isn't it? You can display. 2C is not uploaded.
I'm sorry.
Display, you can display.
Just displayed.
Well, I don't know if it because it's interactive as well, the note, so. It's interactive as well, so it will be helpful. If
No.
I'm not.
I can get it here.
Okay.
Display. It was emailed yesterday.
This holy rising there are two judgments on point 7. Point 7 is, it is established that a strict interpretation ought to be given to laws dealing with corruption, which affects the public weal. But before I take your lordships to that para 5 at page 11, and maybe before it gets uploaded on Justice Sundaresh's system, I could take your lordships to volume 8. There are two judgments which I had alluded to yesterday in the context of section 197 of the CRPC. That was, of course, on the question of sanction, but obviously a similar interpretation would apply between a sanction which is a lower bar and an immunity which is much higher. It's at page 31 of volume 8. It's Horiram Singh versus the Crown. Volume 8, page 31. All your lordships have that?
Yes.
Volume? Yes. Now, this was dealing, my lords, with a situation where one Mr. Henderson had conspired before he fled to Britain to cheat the government out of certain payments that had to be made, and he falsified entries, etc. Interestingly, it was argued by Sir Brojendra Mittal, Advocate General of India, before the federal court. His portrait hangs in, my friend, the Attorney General's chambers. If your lordship will just come immediately to Justice Varadacharya, whose judgment everybody else agrees with, which is at page 55.
How do we take judicial notice of the portrait which hangs in the Attorney General's chambers?
No, it's just that because I in fact had visited the chambers when his predecessor was there, and we had the names of all the previous Attorney Generals with their portraits, and there were two portraits without names below, which were the two Advocates General for India that we had prior to 1940. So one was Brojendranath Mittal. I think the other gentleman's name I forgot, but the names are not there. Maybe that can be repaired. But page 187, because 183 is where the majority starts. Just if your lordships can come to page 180. It's page, no, I'm sorry, I should have read the other page. Why the page number is not here? Huh?
What's the PDF page?
59, sorry. I'm sorry. Yeah, sorry. Page 59, I'm sorry. PDF is 59.
Yes.
At the bottom, that paragraph, if I can just read that. The reported decisions on the application of section 197 of the CRPC are not by any means uniform. In most of them, the actual conclusion will probably be found to be unexceptionable in view of the facts of each case. But in some, the test has been laid down in terms which it is difficult to accept as exhaustive or correct. Much the same may be said even of decisions pronounced in England on the language of similar statutory provisions. See observations in Booth versus Clive. It does not seem to be necessary to review in detail the decisions given under 197 of the CRPC, which may roughly be classified as falling into three groups, so far as they attempted to state something in the nature of a test. In one group of cases, it is insisted that there must be something in the nature of the act complained of that attaches it to the official character of the person doing. Judgments are cited. In another group, more stress has been laid on the circumstance that the official character or status of the accused gave him the opportunity to commit the offense. It seems to me that the first is the correct view. In the third group of cases, stress is laid almost exclusively on the fact that it was at a time when the accused was engaged in his official duty that the alleged offense was said to have been committed. The use of the expression while acting, etc., in 197 has been held to lend some support to this view. While I do not wish to ignore the significance of the time factor, it does not seem to me right to make it the test. To take an illustration suggested in the course of the argument, if a medical officer, while on duty in the hospital, is alleged to have committed rape on one of the patients or to have stolen a jewel from the patient's person, it is difficult to believe that it was the intention of the legislature that he could not be prosecuted for such offences except with the previous sanction of the local government. Two reported decisions, these are from the High Courts of Madras and Calcutta, one in Ganapati Gaundan under 197 and the other in Dakshina Ranjan Ghosh under 80 of the CPC, may be referred to as instructive, since in each of them, two acts were complained of, and notwithstanding the apparent connection between the acts in the sense of relation in time or opportunity, the court held that one of the acts was an official act but not the other. In the Madras case, the village magistrate held in confinement certain persons who were suspected to have committed a murder and also tortured them in order to extort a confession from them. He was charged for committing offences under 330, 343 and 348 of the IPC. Wallace J. held that sanction to prosecute him under sections 343 and 348 was required under 197 of the CRPC, but not for prosecuting him under 330. In the Calcutta case, a trader sued a police officer for recovery of two sums of money, namely 50 being damages for wrongful arrest and 75 being the amount alleged to have been extorted by the police officer from the plaintiff. As regards the second head of claim, the learned judges were of opinion that no notice under 80 of the CPC was necessary, as nobody could suppose that he was purporting to act in his official capacity in demanding and obtaining the sum of rupees 75. Just one quick follow-up, which Malod is at page 65. This is Satwant Singh. It's in 1960. It's page 64 of the same volume. Again, 5 judges judgment, where just one paragraph, if I can read, which is para 16 at page 70, bottom of page 70, 70. If I can read that, para 16, 16. Under section 197, no court shall take cognizance of an offence committed by a public servant who is removable from his office by the Governor General Council or a provincial government, save upon a sanction by one or other, as the case may be, when such offence is committed by him while acting or purporting to act in the discharge of his official duty. Henderson was charged with intentionally aiding the appellant in the commission of an offence punishable under 420 of the Indian Penal Code by falsely stating as a fact in his reports that the appellant's claims were true and that statement had been made knowing all the while that the claims in question were false and fraudulent and that he had accordingly committed an offence under 420-109 of the Indian Penal Code. It appears to us, please mark this, to be clear that some offences cannot by their very nature be regarded as having been committed by public servants while acting or purporting to act in the discharge of their official duty. For instance, acceptance of a bribe, an offence punishable under 161 of the IPC at that time, before the Prevention of Corruption, is one of them, and offense of cheating or abetment thereof is another. We have no hesitation in saying that where a public servant commits the offense of cheating or abets another so to cheat, the offense committed by him is not one while he is acting or purporting to act in the discharge of his official duty, as such offenses have no necessary connection between them and the performance of the duties of a public servant, the official status furnishing only the occasion or opportunity for the commission of the offense. The act of cheating or abetment thereof has no reasonable connection with the discharge of official duty. The act must bear such relation to the duty that the public servant could lay a reasonable but not a pretended or falseful, fanciful claim that he did it in the course of the performance of his duties. Vide Mata Jog Dubey. Now, if your lordship will come back to my note, my lords, 2C. Now, this position has been consistent in Prakash Singh Badal and elsewhere. Over 70 years, your lordships, 80 years, your lordship have followed this kind of reasoning as far as sanction is concerned. Now, the reason why I'm showing this parallel, my lords, is to comment to your lordships two fairly nuanced points. One is this, that in even the minority which we are relying on of Narasimha Rao, there might be one or two things your lordships may just look at again, because I would not believe that that is the correct position. Some aspects of the minority itself. So rather than embracing the minority in full, there are some aspects which may require some kind of clarity, including that arising out of whether you don't give a vote or a speech. Those aspects may require some clarity. But the second aspect is this, that when you interpret the entire cloak of 105 and the immunity that it gives, some distinction has to be made between the various types of activities. Now, in the recent judgment, my lords, which we had referred to yesterday also in Ajit, there was a distinction drawn between what are the legislative and non-legislative functions. Now, it is similar to what virtually every other jurisprudence that we could find comparatively have similar approaches with what is essential and what is part of your duties and where the immunity could lie and where it clearly doesn't and it can't be a part of. Now, if your lordships considers a scenario, for example, because this immunity attends not only proceedings in parliament, but also before committees. Now, those who are appearing before the committees, for example, are not only MPs and MLAs. They may be experts, they may be advocates, they may be people from civil society who have to weigh in, for example, on an environment bill. Or if there is an inquiry into ethnic violence somewhere and Parliament has a standing committee set up and people are coming in to make their statements. Now, if an MP or an MLA who is somebody who may be affected by that committee's findings against him or her were to threaten or intimidate or in any way detain, for example, that witness who's supposed to appear before Parliament. Those are all questions where the MP or MLA may say, this immunity is available to me because it's with reference to a proceeding of Parliament. So it shouldn't be that that cloak is available to that gentleman or that lady for that purpose. That is not the intention. The intention is that the minute it is a criminal act, that criminal act can only be immune if it is very directly related to the speech that is made or the vote that is given. It has to be direct. It has to be proximate. In every sense of the term, it has to be there. So for that proximity to be obtained, in a situation where I threaten or disable an individual from taking the legislative process forward, that is very proximate, because without that, the outcome may have been different. If I detain the balancing vote in Parliament on a particular issue, which may require a by-election to take place or a fresh election to take place, whatever else it is, and I detain the person who's going to give the balancing vote in his house, I am interfering with the legislative process. Because if I had not done that, that person would have come and cast that vote. Similarly, if I had not detained the witness or intimidated the witness would have appeared before the parliamentary committee and made his intervention. So those are very proximate. And it has the test I would suggest is to see the consequence or the effect of that act. If that, I'm sorry, yes, ma'am.
To speak about the connectivity and context is one thing.
Yes.
The reformulating the scope and extent of the immunity is another thing.
Yes.
So what
Yes.
you are now suggesting, as against till now, what the arguments were,
Yes,
is that the crime was before
yes,
the occurrence of the immunity.
yes.
So therefore, it can be bifurcated.
Now,
Now you would want us to also
yes,
give certain conditions on the basis of which this scope of immunity is to be measured.
yes, Manoj, because
Gets into a little difficulty.
I'll explain the reason why. Because, I mean, before 7 judges, these are not adversarial issues. These are issues that we all must be nuanced about. One of the contra arguments which is taken regularly, not only in this jurisdiction but elsewhere, is that if you have a powerful executive, and that powerful executive can then go after legislators and disable legislators if the legislators don't have that protective cloak. So when you have balancing this, you have to be careful of ensuring that the legislators get the immunity that the Constitution intended. That we can't run away from. We shouldn't make the cloak so small that it disappears. So if we are doing that, we have to have some kind of formulation or test on the basis of which we will say this immunity I think is fair and it is deserved. Now, and the immunity obviously will arise, as Mr. Ramachandran said yesterday, only when the crime is there. Because if there is no crime, there is no question of the immunity. The immunity is there is a crime, and then there is a question of immunity. So we take it that there is a crime, but what sort of crime? So the test here is to see what that sort of crime is, because otherwise, if there's no crime, there is no immunity. The crime which we are dealing with is a crime which attends a speech that is given, or as I argue, not given, a vote that is given or not given, as a consequence of something that is extraneous. There, the cloak will not arise if it is in the normal legislative process. Unfortunately, your lordships have seen a live example of this 2 weeks ago, when I don't know if the phrase parliamentary language can be used anymore after what took place. But we saw expletives being thrown around in Parliament. The gentleman who threw those expletives around Parliament took care of ensuring that those words were struck off the record. But what took place was a crime. It's my view. My view is that what took place was a crime. It's many hues of hate speech and many provisions of the IPC would be attractive. But whether we like it or not, palatable or not, it is something he said during a debate, and he said it on a subject. I don't think it would be fair for us to say that that gentleman, however reprehensible his conduct may have been, did not have privilege when he said that.
So an action for criminal defamation will not lie on the basis
No,
of a
no.
speech.
In my view, very clearly no.
Certainly not.
And that's what we're seeing. I mean, we are, our hands are tied. Obviously, we find this repulsive, but our hands are tied and the court's hands are unfortunately tied, because that is the deference that we give to the parliamentary process. It was not germane, but if your lordships were to embark on that inquiry on whether that word you said, this sentence that crept in, was germane to that debate or not, then we are treading on dangerous territory. I don't think we should be going that far. Examining a speech in a particular context and saying that these 2 sentences from the speech is actually constituting something else. But that's the international position.
Case to case basis.
I'm sorry.
Yeah, perhaps is to go case to case basis. It's very difficult to lay down a
general
overarching
test.
proposition saying
No, that's
that far, no further.
no, I agree. So I'm just,
Now can the court say that, well, this was a speech.
yes.
These offending words which you use were unnecessary for the speech. That's not a
That's
part
no
of the
part.
court's
That's
obligation
no
or
part.
duty.
We expect responsible parliament and parliamentarians to take much more stringent action. That's what we expect. We have come to expect. I mean, I'm not normally a conservative, but I feel that this is something that your lordship may look at. Now, I'll just come back to the note, my lords, quickly. If your lordships will just come to point number 7, which is at page 2. And if you'll just tap on that C para 5 at page 11. Just quickly, the very relevant extracts are there. This is page 11. My Lord Justice Sundaresh has the note.
No, no, I'm getting it.
Oh, it's there. Page 11. Just keep checking from here if it's there. Page 11, the first one under 5 is the Subramaniam Swamy case that was under section, I'm sorry, page 11 of volume 2C. It's on the screen also.
I got it, I got it.
So this is in the context of Section 6A of the Delhi Special Police Establishment Act. What was struck down in Vineet Narayan as a single directive, the section provided an additional layer of protection to certain classes of officers, etc. And these are the observations of a unanimous constitution bench there. Para 59. Irrespective of their status or position, corrupt public servants are corruptors of public power. The corrupt public servants, whether high or low, are birds of the same feather and must be confronted with the process of investigation and inquiry equally. Based on the position or status in service, no distinction can be made between public servants against whom there are allegations amounting to an offense under the PC Act. Next para, only the underlined portion. There is no rational basis to classify the two sets of public servants differently on the ground that one set of officers is decision-making officers and not the other set of officers. If there is an accusation of bribery, graft, illegal gratification, or criminal misconduct against a public servant, then we fail to understand as to how the status of offender is of any relevance. Where there are allegations against a public servant which amount to an offense under the PC Act, no factor pertaining to expertise of decision making is involved. Yet Section 6A makes a distinction. It is this vice which renders 6A violative of Article 14. Then page 12, para 72, the bold portion. The status or position of public servant does not qualify such public servant from exemption from equal treatment. The dissent of Justice Prasad and Rameshwar Prasad. But after getting elected, if the candidate deviates from the course of fairness and purity and becomes a purchasable commodity, he not only betrays the electorate, that trust which we had discussed yesterday, but also pollutes the pure stream of democracy. If your lordships will come back, my lords, to the top, there's back to top at the top of each page. So if your lordship just comes back, it'll take you back to the note. Next proposition, that's proposition 8, that's on page 3. The effect of the Rao majority is that it creates an illegitimate class of public servants that are afforded an extraordinary protection, which would be a violation of Article 14 as also being manifestly arbitrary. If your lordship will tap that, it'll take you to page 13. My lords, and at the end of each of these extracts in pages 5 to 18.
So some of your hyperlinks are not come. Uddha dekh lo, hyperlinks क्यों नहीं आ रहे हैं?
The hyperlinks are not coming on that. आपके में आ रहा है ना?
Is it working?
The hyperlinks.
Maybe yours is converted to.
It's not coming any of yours.
No.
The hyperlinks, it's coming.
Oh,
Well,
I'll
it is
just check it
some
out.
system.
That's okay. I'll check it out. Yes, item 8, no?
Yes,
Point 8.
page 13 I was on.
Yes.
Yes, from 8 if you go, it will take you to page 13, top
Yeah.
of page 13. Creating a class of public servants, MPs, MLAs within the broad class of public servants is a violation of Article 14. This is the super citizens, which even Brewster refers to and Narasimha Rao refers to. Justice Khanna in Indira Gandhi. This court rejected that contention and held that the true constitutional position is that so far as a valid order of detention is concerned, a member of parliament can claim no special status higher than that of an ordinary citizen, and that he is as much liable to be arrested and detained under it as any other citizen. In the special courts bill, Malons, Justice Chandrachud speaking for the majority, at para 4, the underlined portion again, it only means that all persons similarly circumstanced shall be treated alike, both in privileges conferred and liabilities imposed. Equal laws would have to be applied to all in the same situation, and there should be no discrimination between one person and another, if as regards the subject matter of the legislation, their position is substantially the same. And finally, this Lokayukta Justice Ripusudan Dayal, the bold portion there, the basic premise for the privileges enjoyed by the members is to allow them to perform their functions as members and no hindrance is caused to the functioning of the House. The Committee of Privilege of the 10th Lok Sabha noted the main arguments that have been advanced in favor of codification, some of which are follows, and this extract. The basic law that all citizens should be treated equally before the law holds good in the case of members of parliament as well. They have the same rights and liberties as ordinary citizens, except when they perform their duties in parliament. The privileges, therefore, do not in any way exempt members from their normal obligation to society, which apply to them as much and perhaps more closely in that as they apply to others. And the next page, that last bold line, no one enjoys any privilege against criminal prosecution. Now, this is a consistent position that your lordships have adopted. final point is the legal position in USA, UK, Canada, Australia, South Africa, and New Zealand supports the minority opinion of Rao, and the same is commended for this court's consideration. This includes an undisturbed line of cases following the majority decision in Brewster. If your lordships were to see at page 14, the extracts, the first is the United States. And this, we have, the extract is there of Article 1, Section 1, Clause 1, which is known as the Speech and Debates Clause, that the senators and representatives shall be privileged for any speech or debate in either house. They shall not be questioned in any other place. The full language of it, my lords, will find in that relevant annexure, Annexure 11. But the relevant parts of Daniel B. Brewster in the majority opinion are these bold portions. I'll just read the small parts of it. A legislative act has consistently been defined as an act generally done in Congress in relation to the business before it. Next, in no case has this court ever treated the clause as protecting all conduct relating to the legislative process. Third one, but no more than the statutes will apply was its purpose to make members of Congress super citizens immune from criminal responsibility. This is where the phrase super citizens comes. And the next one, which is not bold but relevant, para 50. The sweeping claims of appellee would render members of Congress virtually immune from a wide range of crimes simply because acts in question were peripherally related to their holding office. Such claims are inconsistent with the reading this court has given, not only to the speech or debate clause, but also to the other legislative privileges embodied in Article 1, para 6. Next page, page 15. There is no need for the government to show this para 62. There's no need for the government to show that appellee fulfilled the alleged illegal bargain. Acceptance of the bribe is the violation of the statute, not performance of the illegal promise, similar to us. Taking a bribe is obviously no part of the legislative process or function. It is not a legislative act. Now, this is followed in the judgments of Gravel, McCrade, Renzi, and the extract here, and Menendez. Here we have taken out the extracts only of Gravel and Menendez. The entire details you'll find in Annexure 11. White's opinion, speaking for the court in Gravel, is legislative acts are not all encompassing. The heart of the clause is speech or debate in either house. Insofar as the clause is construed to reach other matters, they must be an integral part of the deliberative and communicative processes by which members participate in committee and house proceedings with respect to the consideration, passage, or rejection of proposed legislation, or with respect to other matters which the Constitution places within the jurisdiction of either house. While the speech or debate clause recognizes speech, voting, and other legislative acts as exempt from liability that might otherwise attach, it does not privilege either senator, or aide to violate an otherwise valid criminal law in preparing or implementing legislative acts. Now, Brewster has been consistently followed in the US. The latest case is this 2016, which is Menendez. And there are these two paragraphs, specific sentences. Opinion of the court is Justice Ambrose. First, we look to the form of the act to determine whether it is inherently legislative or non-legislative. Some acts are so clearly legislative in nature that no further examination has to be made to determine the appropriate status. Examples of manifestly legislative acts include introducing and voting on proposed resolutions and legislation, introducing evidence and interrogating witnesses during committee hearings, subpoenaing records for committee hearings, inserting material into congressional record, and delivering a speech in Congress. On the other side of the spectrum, some acts are so clearly non-legislative that no inquiry into the content or underlying motivation or purpose is needed to classify them. Examples include legitimate constituent service, such as the making of appointments in government agencies, assistance in securing government contracts, preparing so-called newsletters to constituents, news releases and speeches delivered outside the Congress, and of course, illegitimate activities such as accepting bribes in exchange for taking official action. This is echoed, my lords, in your lordship's judgment in Ajit, and I would commend that this be the test that your lordships will apply. That if it is an illegitimate, your lordships can see the three categories here which the US Supreme Court has adopted. One is manifestly legislative acts, the second are clearly non-legislative, and the third is illegitimate activities. What Narasimha Rao's majority has done is taken illegitimate activities and said, no, even they had received the cloak of protection. And I don't think that was intended. Well, the rest of it is, and I'm sorry, bottom of page 16. 16 deals with the UK. Just the Joint Committee on Parliamentary Privilege. This is a report of 1314. If I can just read the bold portion. Requesting or agreeing to receive a bribe are now statutory criminal offences, irrespective of whether or not the acts for which the bribe was sought or offered are actually carried out. This makes the situation in the United Kingdom analogous to that in the United States, where the case of US versus Brewster established that a senator could be prosecuted by demonstrating that an unlawful agreement was entered into without the need to show that the bribe led to specific conduct, which may be privilege. Similar views in Australia. In Canada, my friend, the amicus read R versus Bunting. We have also extracted the criminal codes in each of these countries, my lords. And for a minute, if your lordships would just go to, Annexure 8, which is page 112. I'm not going to read it. I'm just going to explain how we have split it up. Page 112, that's Annexure 8 of this one. Annexure 8. Your lordship will see that first page, page 112, deals with United States. So we put the statute, the relevant statute or the clause of the Constitution at the top, and the relevant clauses of other related laws. Then the case name on left, the facts, and the extracts of the opinions, majority, minority, whichever is relevant, including highlighting in red what we would want your lordships to consider. In this light, before concluding, I just want your lordships to look at, and there are others to argue, so I'll just mention the paras. In Narsim Rao, if your lordships will kindly just see para 45, 47, 50 and 52. Now, these are parts of the majority judgment, minority judgment. 45 deals with the fact that a punishment by the House is not satisfactory. 46 is the interpretation of in respect of. 47 deals with the question of the vote or the speech already having been cast. And the question of something already having taken place is only where the words can be read as arising out of, where it has already taken place. There is one small issue there. If your lordship sees page 752, volume 5, page 752. Last sentence there on that page, which is part of para 47, if I may read that, the immunity, or the second last sentence, 4 lines up, the immunity from liability, therefore, comes into play only if a speech has been made or vote has been given. The immunity would not be available in a case where a speech has not been made or a vote has not been given. But I would feel that this is problematic and this would not be the correct position, despite it being in the minority. Then the next page deals with that distinction and how our founding fathers did not mean for a distinction between what eventually took place, between those who voted and those who did not vote in a specific fashion. And para 50 deals with when the offense is complete, because that aspect was also considered. And para 52 says that the criminal liability for taking the bribe was independent completely. These other paragraphs, which I've mentioned, I think should be the correct position and should be followed, my lords. If your lordship will just now come to the judgment in Ajit, which is in volume 5, starts at page 2680, my lords. 2680, and I just want to read 2 specific parts of it. The first is para 74 to 75, which is at page 2704. Volume 5, page 2704. May I read that? All your lordships have it?
Volume para?
Para 74,
Yes.
it's page 2704.
Yes.
Privileges and immunities are not gateways to claim exemptions from the general law of the land, particularly as in this case, the criminal law which governs the action of every citizen. To claim an exemption from the application of criminal law would be to betray the trust which is impressed on the character of elected representatives as the makers and enactors of the law. The entire foundation upon which the application for withdrawal under 321 was moved by the public prosecutor is based on a fundamental misconception of the constitutional provisions contained in 194. The public prosecutor seems to have been impressed by the existence of privileges and immunities which would stand in the way of the prosecution. Such an understanding betrays the constitutional provision and proceeds on a misconception that elected members of the legislature stand above the general application of criminal law. The reliance placed by the appellants on P.V. Narasimha Rao to argue that the action of the respondent accused inside the House was a form of protest, which bears a close nexus to the freedom of speech and thus is covered by 194, is unsatisfactory. The majority in Narasimha Rao dealt with the interpretation of the phrase in respect of and gave it a wide import. At the same time, the majority observed that there must be a nexus between the act or incident, which in that case was the act of bribery in the context of votes cast on motion of no confidence, and the freedom of speech or to vote. It was emphasized that the bribe was given to manipulate the votes of the MPs, and thus it bore a close nexus to the freedom protected under Article 1052. The case, however, did not deal with the ambit of the privilege of freedom of speech provided to the members of the House. It was in Lokayukta Justice Ripusudan Dayal that a three-judge bench of this court laid down the law for the identification of the content of the privileges. It was held that the members shall only possess such privileges that are essential, please mark this, Malaj, for undertaking their legislative functions. An alleged act of destruction of public property within the House by the members to lodge the protest against the presentation of the budget cannot be regarded as essential for exercising the legislative functions. The actions of the members have trodden past the line of constitutional means and is thus not covered by the privileges guaranteed under the Constitution. So this is a test which I would commend for the fact that it has to be essential for undertaking the legislative functions. It's a better test than the test of proximity of in time or that the vote or speech is already completed. The question is only whether while giving that speech or casting that vote, was it a part of the essential legislative function which was done? If it was done, you have the protection. But if there is any interference with that flow of what the wheels of parliament or legislature are undertaking, if there is any interference of any sort, that cloak cannot come to protect. That protection would not be available. I'll just finally say one thing. There is an article by Professor Shubhankar Dam, which is annexed. I'm sorry?
Ordinance. He's written a book on ordinance.
He's written a book on
I in
ordinance.
fact cited it, I think, in my judgment
Yes.
in Krishna Kumar Singh, I think.
Yes. So he in fact has written a series of very, very well-researched articles, including on the constitutional right to vote and whether it's a constitutional right or not, etc. But this one is specifically with reference to, it makes for interesting reading, especially I think if you're a judge, because he talks in like how many writers write about philosophies in the US. Same way he talks about Narasimha Rao and Rajaram Pal and the philosophies which attended them.
Where is that article?
See the page numbers, it's 1951 of volume 6. 1951 to 1953. I know. I'm just taking the relevant portion. 1951 to 1953 is where Narasimha Rao is discussed. And he says how perhaps the Supreme Court had a revisiting of its philosophy between Narasimha Rao and between Rajaram Pal. But I'm done. I would just believe that the minority lays down the correct law. I'm grateful for a patient hearing. 2 points of gratitude quickly. I'm sorry. 2 points of quick gratitude. One, I have a very able team of lawyers who've put all of this together. I'm some of their parts. So Tanya, Vishal, Janvi, Trisha, Shivani, and Aditi. And Mr. Ramachandran, because he repeatedly stands in this court and takes completely difficult cases and somehow makes arguments out of them. He's an example to all of us at the bar. I'm most grateful.
I suppose the second part.
Yes, my lord, we are-
Yesterday, I think did a very good job of.
With it, in a rough weather, my lord.
Yeah.
And unpopular cases.
Yes, yes. Yes, Mr. Ansari.
My lord, I'm pleased. My lord, my submissions, your lordship will get it in volume 2A, page 47. volume 2A, page 47, my submission starts. But before I take your lordship to the submissions, my lord, may I just briefly summarize, my lord, what I intend, my lord, to persuade your lordships, my lord, to agree with the minority view, to say that, my lord Justice Bharucha, my lord, the test propounded is the nexus test. And Justice Agarwal propounded essential and integral part test. Lord, my lord Justice, nexus test is in paragraph 133, 134, 135, 136, and 145 of Narasimha Rao judgment. Justice
133, 134.
133, 134, 135, 136, and 145 is the nexus test propounded and, my lord, held to be the correct law by the majority. And, my lord Justice Agarwal test was essential and integral part test in para 47, which my friend Mr. Sankarana also said essential and integral part test would be the correct test, my lord. And, my lord, lordship would kindly make a note, my lord. It is not only a case of bribery. It will...
Justice Agarwal is para 46. No?
Para 47, my lord. I'm so sorry. Para 47 is the, my lord, essential and integral part test. And I'm so. And, my lord, what your lordship says is not only in relation to an offense of Prevention of Corruption Act. It gives immunity to all sorts of crimes committed, my lord, if at all. Hopefully not, my lord. Suppose, my lord, there is a nexus with an underground organization, terrorist organization, to vote in a particular manner. There is a meeting on a previous day. And say that a terrorist organization says you don't vote or vote in a particular manner. It has a nexus. If nexus theory is accepted, my lord, that immunity is applicable to an offense under the UAPA Act also. That offense is that immunity is available to an offense under the PMLA Act also, or various other acts, my lord. So, my lord, to say that it's only, my lord, the bribery issue is involved, my lord, what your lordship would say, my lord, would it involve all crimes, my lord, which unfortunately we have, my lord, the list of more than 5,000 cases pending against, my lord, the legislators in the country. And it is not a spray incident of 1 or 2 cases, my lord, which has come to a lordship, my lord, in Narasimha Rao or in this case, my lord. With that preface, my lord, may I just humbly meet, my lord, the 4 submissions which my learned friend Mr. Ramachandran made, my lord. And, my lord, take your lordship to my written submissions thereafter. The first test, my lord, first submission which my learned friend Mr. Ramachandran said that it has stood by the test of time, Narasimha Rao judgment, my lord, which is not correct, my lord. Your lordship have repeatedly doubted it, my lord. And Mr. Sankarana has dealt with the aspect. I don't want to give it, my lord. If mistake is there, it must not be perpetuated, my lord. That is what your lordships have held. The second is, my lord, more disturbing. My learned friend says that corruption is a way of life in our political spectrum. Accept it, my lord. Which, my lord, cannot be done, my lord. Ayaram, Gayaram has been there in 1967. It is there, it was there, and it will be there. So turn a blind eye to this, my lord, which I would commend your lordship to say, my lord, to interpret the privilege in a manner which will not flourish the, my lord, the criminality among the politicians or the political class. It will, my lord, curb the criminalization of politics, and it will not surge it. An interpretation your lordship would give. So that's saying that you accept the reality, and the court should turn a blind eye, my lord, that yes, it will be there, it was there. It should not be a correct, my lord, proposition of law. Because, my lord, I will give you the facts, and it is there in the on record available to the court, my lord, that how many cases are there. We have cases, my lord, more than the parliamentarians or the legislators in the country. We have total 4,778 lawmakers in the country, my lord, all MLAs, all MPs, both houses. And we have more than 5,000 cases against the politicians, my lord, pending in the courts as on date, my lord. So would your lordship say, my lord, all that the person has to say, I have this offense is a nexus with I have done in the house. Nexus theory is sufficient to exclude him from the criminal liability. But that interpretation would go against the constitutional ethos, my lord, against the constitutional morality, which I have developed in my written submissions. My lord, my learned friend also says that the Justice Agarwal said it's not a satisfactory solution the court is not there to satisfactory solution. It is the parliament which will deal it. And my learned friend gave 5 examples, my lord, since 1947 till 2023, where parliamentaries has been expelled for some time. My lord, is it a substitute, my lord? We know, my lord, these offences have been there, and my lord, for 5 occasions, it has been expelled for, say, 5 days, 10 days, 15 days, a month. Thereafter, my lord, he comes back as a member of parliament. But if he is convicted in a criminal offence, my lord, he cannot come back. And as on date, my lord, till 6 years of the release, he does not come back. He cannot contest the election. So he cannot continue to be a parliamentarian, my lord. But if those 5 instances is the sufficient, my lord, exercise of power by the legislature or the house, my lord, which, as Mr. Sankaran said, we expected much more, my lord. It has not happened. So, my lord, it has to be taken into consideration, my lord. That is not a satisfactory solution as observed by my Lord Justice Agarwal. And finally, my learned friend says there is an apprehension, my lord, of misuse. My lord, apprehension of misuse is being said by a person who has taken 1.5 crore to vote in a house, in an election, my lord. And my lord, there is a sufficient safeguard. There is a sanction is required for prosecution by the chairman and the speaker, my lord. Where is the question of, my lord, a frivolous prosecution? You require the sanction of the chairman of the Rajya Sabha. You require the sanction of the speaker of the Rajya Sabha. So there is a sufficient safeguard, my lord, against any apprehended misuse of any provisions, my lord. With this preface, my lord, may I request your lordship, my lord, to kindly come to volume 2A, page 47. The first 2 pages are regarding, my lord, issues involved. Your lordship has already considered it at great length, my lord. At page 49. It is submitted that, my lordship, what?
Yes.
Yes. That the constitution must be interpreted having regard to the challenges and evolution over a period of time and must reflect the hopes and aspirations of the people. It is not a frozen document, my lord, which I borrowed it from your lordship's judgment, my lord. I'll just quoted it subsequently. And must be interpreted to meet exigencies of time. My Lord Justice Chandrachud's lordship then was in Puttaswamy held. The interpretation of the constitution cannot be frozen by original understanding, which is sought to be canvassed, my lord. And constitution has evolved and must continuously evolve to meet the aspirations and challenges of the present and future, nor can the judges foresee every challenge and contingency which may arise in future. Lord, we never foresee, my lord, that so many persons with criminal background would come to the August House of Parliament, my lord. But this is what has happened. So it has to be in that context. Then in Kalpana Mehta, the Chief Justice Deepak Mishra said, Constitution being an organic document, an ongoing interpretation is permissible. The supremacy of the Constitution is essential to bring changes. Then while doing so, the constitutional courts are not only required to take into account their own experience over time, international treaties and covenant, but also keep the doctrine of flexibility in mind. And my Lord Justice Chandrachud has said, my lord, in the same judgment, in finding an answer to the question in reference, this question must of necessary travel from a literal and perhaps superficial approach to an understanding of the essence of what the Constitution seeks to achieve. At one level, our Constitution is overseen the power of political power from a colonial regime. Lordship may skip over that, and last 3 lines of, my lord, page 50 of our interpretation of the Constitution must reflect a keen sense of awareness of the basic changes of the Constitution has been made to the polity and to its governance. A 5-judge bench in Dawoodi Bohra community has laid emphasis that the Constitution must be interpreted as a living instrument considering the changes in the society. My Lord Justice Oka has held in that judgment, my lord. Para 25, while interpreting the constitutional provision, we must remember that the Constitution is a living instrument. The organist interpretation rendered by the provisions of the Constitution decades back cannot continue to be valid for all times to come if the Constitution is to continue as a living instrument with continued relevance. In view of what we have stated above, the role of the Constitutional Court to interpret the Constitution, considering the changing need of the society, assume importance. In the light of the aforesaid pronunciation by this court, my lord, yes, my lord, all these 11 pages are, my lord, given, my lord. I have filed this before the compilation was available, so I have not linked that, my lord. Maybe I'll give it to the court master, because these are, my lord, in compilation 5, page 2794. I could not give it because I filed it, my lord, before that convenience compilation was there. So I'll just give those, my lord, to the court master so that it can be linked, my lord. or in the light of the aforesaid pronunciation of law by this honorable court, it is respectfully submitted that the issue of immunity from criminal prosecution by the legislators under Article 1052 of the Constitution need to be interpreted in the present context. I'm so sorry. In the present context, where there is extensive criminalization of politics and large number of persons with criminal antecedents have entered the parliament and the legislative assemblies. Now, these figures are very startling, my lord. These are, my lord, from the proceedings, my lord, in another case, this honorable court in PIL, filed by Ashwini Kumar Upadhyay, directed setting up special courts and MPs, MLAs, and passed a series of directions. However, the number of pending cases have increased from time to time, and the number of cases, my lord Justice, Chief Justice, my lord Justice Nashima, my lord Justice Mishra has heard this, my lord, but for your lordship's benefit, my lord, on other honorable judges on the bench, in December 2018, there were 4122 pending cases, of which, my lord, 1675 were against MPs and 2324 against the MLAs. Out of these cases, cases involving life imprisonment or death penalty were 430. So 430 cases of life imprisonment were pending against legislatures, 180 against sitting MPs and 250 against the former MPs or MLAs. In December 2021, after lordships have passed series of directions in that case for expedite trial, the number of pending cases were increased from 4984, out of which 1899 were pending for more than 5 years. November 2022, the number of cases further increased to 5175, out of which 2166, 40% cases are more than 5 years old. Now, in a report of the Association for Democratic Rights, 234 out of 542 members of Lok Sabha, 71 out of 236 members of Rajya
Nobody is
Sabha.
claiming a 105 privilege in any of those.
Well, this shows that lordship would take into account these figures while interpreting the provisions of the Constitution. That's what I'm trying to emphasize to your lordship, my lord. Then, my lord, there are various reports and
go straight now to page 61, parliamentary privilege, not a shield to commission of crime. That is
your lordship, my lord. My lord. Para 61, my lord, page 61. Before that, can I just 2, 3 or pages, my lord, just show to your lordship before 2 or 3 pages, my lord. There are various reports, my lord, which I have quoted, lordship, including Justice
the National Commission for Review of the Constitution, Justice Venkatacharya.
Yes, my lord, yes, my lord, Justice Venkatacharya
they
report.
cast doubt on TV Narasimha Rao.
Directly honorable, that commission says, my lord, it's a wrong view, my lord, and it may be corrected. And my lord, in Law Commission's 239 report headed by Justice Reddy, 244th report headed by Justice Shah, my lord, has read this. And at page 54, my lord, that Justice Venkatacharya Commission has specifically says, it is obvious, my lord, page 54, middle of that page, my lord, that quotation from that report. It is obvious that this interpretation of immunity of members of parliament run counter to all notions of justice, fair play, and good conduct expected from the members of parliament. I can say no more, my lord. Freedom of speech inside the out cannot be used.
62, actually now page 62.
My lord.
You formulate the test.
The
expression with respect of must be interpreted to mean only those acts that are essential for undertaking the legislature.
Yes, my lord.
You are adopting the test of the...
Yes, that is the crux of my submission. Before that, can I just show to your lordship, my lord, volume 4, page 1513, what May has to say, my lord, and I'll commend your lordship to accept that interpretation. Volume 4, page 1513. It starts, and yes, paragraph 16.4. I'm so sorry.
What is this document? This is a.
No, this is the document starts, my lord, from, it is a May's parliamentary practice, my lord.
It starts.
Yes.
Okay,
The document starts at page 1502. 1502. 1501 rather, heading cover page is there, my lord, 1501. And at 1513, my lords have got it. Yes. Early and mid 20th century, many subsequent cases have their origin in the desire to determine the proper limits of the statutory phrase proceedings in the parliament, some of them with a particular concern of what is integral part of parliament or to parliament in the context its claim to exclusive concern. In general, the judges have taken the view. Now, this is what I want your lordships to kindly consider and accept this proposition, lord, that when a matter in a proceeding of the House, beginning and terminating within its walls. Lord, as Mr. Sankarana said, Lord, there was a statement recently, we may not like it, my Lord, but it has been said within, beginning from and terminating within the walls of the House, my Lord, that is privilege, that nothing can be done. Obviously, outside the jurisdiction of the court. Lord, so my Lord, the expression is beginning and terminating within the walls, within its own walls, would be privileged, my Lord, but nothing outside it, my Lord. And same thing is been said, my Lord, at page 1514. At the last two lines of the first paragraph, my Lord, page 1514, he contrasted those with rights to be exercised out of and independently of the House. I will say, my Lord, rights and liabilities. I'll add that word, my Lord. Rights and liabilities arising out of and independently of the House, in which the court must be the arbiter. Yes, my Lord. Yes, even within that, my Lord, I'm grateful to Mr. Patwali. I'm not learned amicus. I can read that, my Lord, 1513 again, the last lines. In general, the judges have taken the view that when a matter in a proceeding of the House, beginning or terminating within its walls, it is obviously outside judicial court unless criminal acts are involved. So there also, my Lord, if the criminal act is involved, it is not. So, my Lord, an interpretation which protects the criminal act is definitely outside the, my Lord, the privilege, my Lord. And what right or liabilities arise, my Lord, independently of the House, the court is the arbiter. That is the test, my Lord, which the May has said, and I'll appeal to your Lordship to accept that test, my Lord, and lay down that as the correct law. Now, my Lord, may I just summarize, my Lord, as my Lord, the Chief Justice has said, my Lord, page 62, para 27 to 29. That is my final submissions, my Lord, which I am beseeching your Lordship to accept. It is submitted that the majority judgment granting immunity to all the acts of Parliament that relates to, that is, my Lord, para 133, the nexus, my Lord, relate to or concern or have a connection or nexus. So these four expressions, my Lord, does not correlate, my Lord, which is sought to be, my Lord, immune, which is too wide, my Lord, with anything said or vote given in Parliament is too wide and does not encompass within the expression in respect of used in clause 2 of Article 105. The expression in respect of must be interpreted to mean not only those acts, or must be interpreted to mean only those acts which are essential for undertaking the legislative function. No privilege can be claimed from criminal prosecution. The penal laws of the country are applicable to the legislators in the same way as are applicable to ordinary citizens. The privileges are only those which begin and terminate within the walls of the House, as May has said, my Lord. All actions outside the House are subject to adjudication by the courts. The immunity conferred by Article 105(2) and 194(2) is confined, is only a qualified immunity and not an absolute immunity. The qualified immunity balances two competing rights, namely grant of freedom of speech and expression to the vote in the Parliament inside the House and hold them accountable for any crime committed outside the House. My learned friend will deal with it. It is submitted that commission of any crime can never relate to, in respect of anything said or vote given by him Parliament, and no legislator can claim immunity from criminal prosecution by seeking the protection of parliamentary privilege conferred under Article 105(2) or 194(2). Every person is liable for prosecution for offences committed by him or her under the penal law of the country. If immunity from prosecution is granted, the criminalization of politics will get a boost instead of being curbed. The immunity would be an easy escape for the lawmakers to avoid penal consequences of all penal offences, including heinous offences, by claiming that such an act was in respect of anything said or done or vote given by him in Parliament. The immunity, if allowed, would be limited not only to corruption cases, which I started saying that, but it can be claimed in respect of serious offences such as POCSO, Unlawful Activities Act, Money Laundering Acts, hate speech, etc. It would be licensed for the legislator to commit a crime without fear of prosecution and thereafter claim immunity by creating a so-called nexus with the speech or vote given in the House. It is submitted that the criminalization of politics has been deep-rooted in the parliamentary democracy of our country. The parliament and legislature cannot seek immunity from prosecution, the garb of parliamentary privilege. The majority in the Nashima Rao only encouraged the people with criminal antecedent to enter politics, enter the precincts of parliament street cliche, and the number of such people will surge, increase or expand instead of being truncated or brought down. So, my lord, I appeal to your lordship, lord, that the minority judgment, my lord, maybe.
Thank you, Mr. Patel.
Lord,
Thank
there
you.
are, my lord, may I just say this, my lord? Lord, the additional submissions which have been made, my lord, there are 4 councils who wish to address your lordship, lord, which is in volume 8, my lord, there are four councils which have said. Lordship may give 5 minutes to each of them, my lord, the 4 councils who have said, my lord, in that order only, my lord. Ms. Kalita, Dr. Sharma, Mr. Banduri, and Ms. Karyawaj, however, my lord. Lordship, huh? I'm saying that let it be in the same order. That's what it will be easier.
Yes. Mr. Bandari, you want to speak? We'll hear Mr. Bandari for 2 minutes and then we
Yes,
can.
Your Lordship. I would take 2 minutes of your Lordship time.
All right, yes,
And I'm
tell
grateful
us.
to your Lordship. Your Lordship, my submission, I have given a short submission, Your Lordship, in volume 8, page number 3 and 4, volume 8. Your Lordship, my humble submission would be that the parliamentary privilege, Your Lordship, I would wish to read from my note.
Just one second.
Your Lordship, Justice Nashima has.
Yes.
Yes. My humble submission, Your Lordship, is that the parliamentary privilege and the immunity that are conferred on the members under Article 1052 and 194(2) of the Constitution of India for smooth functioning of the Parliament, so that they can vote and speak without any fear, which has been quoted in State of Kerala versus Ajit, Your Lordship, which is referred in volume 5 of page number 2996 of para 44. Your Lordship, it is respectfully submitted that such privilege has to be read in consonance with the basic structure of the Constitution of India. And if the privilege is treated in an absolute shield, then the very essence of the democracy for the protection of the rights of the citizens will be lost. Therefore, Your Lordship, the legislators are the citizens' representatives and the work for the welfare of the people. And therefore, they are the lawmakers and cannot be the lawbreakers. Secondly, Your Lordship, my humble submission is that the reason for grant of immunity in respect of anything said or vote given was to ensure that inside the House, the statement made should not be criminally punishable. But today, Your Lordship, this privilege has taken the color of criminalization, and the provision is being misused under the cover of broad interpretation given by the majority of the judgment in the case of P.V. Narasimha Rao. Your Lordship, my humble submission is that the immunity was never intended to place the parliamentarians at the higher pedestal and the grant immunity to them, no matter how grave or the criminal their acts might be. Your Lordship,
You're adopting the minority's test
So,
of
Lordship,
arising out of.
adopting
Fair enough.
the view. And Your Lordship, therefore, if the members of the Parliament have done unethical acts and otherwise contrary to the law, which is out of the periphery of the discharging their parliamentary duties and responsibilities, then they should not confer the immunity.
Thank you.
And thirdly, Your Lordship, in respect of Your Lordship, the term, the interpretation, Your Lordship, in respect of should be interpreted to mean arising out
Right.
of, and therefore it should be purposive interpretation, limiting the immunity granted under clause 2 to
Now, who's,
only those acts and the words
fair enough.
were said
We'll have a
inside the
look,
House,
Sneh, thank
which is
you.
also include mere participation, Your Lordship.
Now, the next submission we have was of Dr. Vivek Sharma, right?
Grateful, Your Lordship.
Thank you, thank you. Volume 8,
Page number 6, sir.
volume 8, page 6,
Page number
right?
6, sir.
Right, let's see what you have
To
said.
decide the basic issue, the immunity from the criminal prosecution involved in this case, 3 points should be kept in the consideration. What was the intention of our constitution makers under Article 105 and 194? And the second point is that whether in democracy a voter can expect from his elected representative that he should be allowed to take money or bribe for speech or vote in the House. The third one is whether immunity from the criminal prosecution for taking bribes, money for vote or speech in the House to MPs, MLAs is creating the different class who are allowed to corrupt the basic foundation of the democracy. In a healthy and honest democracy, elected representative is for the service of nation. There is no place of immunity for taking bribes or cash. And the last one, and the D point is that our constitution makers took the different provision of the constitution from the world democracies according to Indian perspective. They borrowed parliamentary form of government from the United Kingdom, but they did not accept the parliamentary supremacy. Their ideals and aspirations are very high for the newly born Republic of India. Our constitution makers never wanted that. By the virtue of privilege under Article 105 and 194, the lawmakers would seek criminal immunity from the bribes. It is not only the immoral, but also destroys the basic structure of the democracy. Today, lawmakers would took bribes or money for vote or speech in the House. Tomorrow, the voters would take money for the vote. Then what would happen? Certainly, there is no place for immunity from criminal prosecution for taking bribes or money for vote or speech in House to MP and the MLAs. So the minority statement in the PV Narasimha Rao case, I think so.
Thank you. Thank you, Doctor. Yes, Mr. Bhandari.
I'm going to take very briefly, Milods. I think the debate has surrounded Milods, and we've looked at it from a perspective where we are all looking at it as a person, as a parliamentarian who accepts some money before he walks into the parliament and votes in a particular manner. But Milods, there will be a large number of permutation and combinations. There could be a parliamentarian, Milods, who takes no money, walks into the parliament, votes in a particular manner, but comes out and then after that takes certain illegal gratification. So while, yes, Milods, I support as an intervener that the cloak should be trimmed, but Milods, how far it should be trimmed and what should be the boundaries is something that this court should endeavor to set it out. Now, the minority view in Narasimha's case and the majority view both look at American jurisprudence, both look at the Brewster's judgment, which has been read to this court. The minority, Milods, when they look at Brewster's judgment, they come out with a test that it should be an essential and integral part of the cause of action. Now, Milods, to say that it should be an essential and integral part of the cause of action would leave, Milods, a lot of parliamentarians, Milods, to prosecution, would be my humble submission. And therefore, there needs to be a far more rigid test that needs to be propounded and needs to be laid down. Because, Milods, we in a Westminster form of parliament are not only, Milods, parliamentarians don't necessarily belong to a big political party. We have to also ensure that the cloak is strong enough to protect, let's say, an independent member of parliament. So therefore, when a cloak is being trimmed, there should be some checks and balances to ensure that false prosecutions and prosecutions which necessarily penetrate the cloak and starts looking into what the parliamentarian did in the parliament should not be allowed. Now, Milods, this, according to me, this test which is propounded in the minority judgment of Narasimha, Milods, is actually, Milods, in tandem with all the judgments in the US. Now, Milods, before Brewster came, there was a very important judgment, Milods, called Johnston. And Johnston has been critically, Milods, analyzed in the American jurisprudence as saying that it gave too much of protection to parliamentarians. However, Brewster, Milods, did not overrule Johnston, or did not say Johnston is wrong law, rather explained that Johnston was right law. Milods, I just wanted to show you one or two paragraphs of Johnston's to show that really, even if one looks at Johnston, which is seen as a very restrictive case, still the test propounded there would also work in our Indian context. Milods, Johnston is item number 13 in volume 5A. Item 12, Milods. It's page 202, it starts in volume 5A. Now, interestingly, Milods, Johnston's notes that the reason this whole immunity came was not only to save the parliamentarians from the crown, but also from the judiciary. And way back, the more fear was the judiciary acting at the behest of the crown. And that's why this protection came in. So, Milods, the reasons might be quite misplaced in today's times. And therefore, Milods, those reasons may not apply. But Milods, I don't want to take the time of the court because I know I'm on very limited time. I don't want to read why the protection was given, but it's very well explained at para 3 and 5 and 6. But Milods, I want to come to straight at the test. If I can read para 15, Milods, in Johnston, because Johnston is seen as something which is far more expansive and gives more protection to a parliamentarian than what he deserves. That's page 205, para 15. In the same vein, the government contends that the speech or debate clause was not violated because the gravamen of the count was the alleged conspiracy, not the speech, and because the defendant, not the prosecution, introduced the speech itself. Whatever room the Constitution may allow for such factors in the context of a different kind of prosecution, we conclude that they cannot serve to save the government's case under this conspiracy count. It was undisputed that Johnson delivered the speech. It was likewise undisputed that Johnson received the funds. Controversy centered upon the question of who first decided that a speech was desirable, who prepared it, and what Johnson's motives were for making it. The indictment itself focused with particularly upon the motives underlying the making of the speech and upon its content. I won't read the charge, my lords. In para 16, we hold that a prosecution under a general criminal statute dependent on such inquiries necessarily contravenes the speech or debate clause. We emphasize that our holding is limited to prosecutions involving circumstances such as those presented in the case before us. Our decision does not touch a prosecution which, though as here founded on a criminal statute of general application, does not draw in question the legislative acts of the defendant member of the Congress or his motives for performing them. And without intimating any view thereon, we expressly leave open for consideration when the case arises a prosecution which, though possibly entailing inquiry into legislative acts or motivation, is founded upon a narrowly drawn statute passed by Congress in the exercise of its legislative power to regulate the conduct of its members. So, my lords, here the court clearly says it does not touch upon a prosecution, though as here founded on a criminal statute of general application, does not draw in question the legislative acts of the defendant member of the Congress or his motives for performing them. So, my lords, the issue is not what he did when he entered the parliament. What speech did he make, who prepared it, and how he prepared it, and how he delivered it, and how much did he emphasize on certain aspects of his speech in favor of someone. What matters is what he did before entering into the parliament, or what he did after he exited the parliament in pursuit of a criminal agreement for illegal gratification. So whether the bribe is paid before or after would have no consequence, because that act would not be actually looking at the content of the speech. The court, my lords, in Brewster, then, my lords, says at para 39, at page 216, and this is, my lords, I think the aspect that comes out. Brewster doesn't say that Johnston is bad law. It explains Johnston's by saying that the prosecution should be able to make good the charge without asking the prosecution to adduce evidence as to what happened in the parliament. So it does not matter, my lords, how he voted, because even a bribe taker, my lords, may cheat the bribe giver. But that is not the gravamen of the offense. The offense is that he agreed and accepted to take a bribe. Section 7 of the Prevention of Corruption Act, my lords, of our country does not inquire whether actually the bribe taker did perform what the bribe giver asked him to do. The fact that he agreed to do something is good enough for the offense to happen. Therefore, one does not need to look into what happened inside the parliament. And that is where should be the hard boundary, that can the prosecution make a charge and take it good to the end without looking into what actually happened inside the parliament. What was the tenor of the speech, whether he voted in a particular manner or not, or whether he abstained from voting or abstained from voting. If that is the test, that whether prosecution can be brought in without scrutinizing the act inside the parliament, my lords, within the confines of the parliament, then, my lords, according to me, that the cloak would be good enough to protect what its intention was, to protect the freedom of the parliamentarian. And, my lords, para 39 in Brewster really catches that.
Yes.
Para 39 and para 62 in Brewster catches that. So, my lords, even judgments in the US, which have taken a slightly different view from Brewster, have been reasoned. And, my lords, the last judgment, I'm not going to read it, my lords, but where, which was not cited in Narasimha, it was actually there at that time, which considers both Brewster and Johnston, is in, my lords, volume 6, which is very important. It's McDay, my lords, US versus McDay, which is, my lords, the relevant paragraph is at page 294, where the court says that yes, prosecution can't bring in the evidence as to what happened in the parliament. Prosecution has to make its case good on what happened outside the parliament to bring home a charge, but the defense can. So, my lords, It will not stop a parliamentarian to show, oh, you are charging me for corruption, but actually I did not vote in such a manner. So he might be able to bring in, but the prosecution cannot. And that is where the test should be. I'm deeply obliged.
Thank you, Mr. Mehta.
If I may please, my lords, my submissions start from page 22, volume 8.
Yes.
My lords, my submissions would be limited to the interpretation of the term in respect of. My lords, clause 1 of Article 105 confers freedom of speech in Parliament, subject not only to other provisions of Constitution, but also to rules and standing orders regulating the procedure of Parliament. Thus, the freedom of speech is not absolute, but is subject to various other provisions as has been mentioned in the article. My lords, clause 2 grants immunity to the members from proceeding in any court in respect of anything said or vote given by him in Parliament. My lords, my humble submission is the first part of clause 2 has to be juxtaposed with the second part and cannot be read in isolation. They both have to be read together. Further, my lords, the term in respect of cannot be colorably exercised by parliamentarians to cover within its ambit of being involved in any act or conspiracy or crime outside the walls of the House. There is no reason to grant complete immunity by interpreting the word in respect of to mean anything that relates to or concern or have connection with or nexus as held by majority judgment of Honorable Justice Bharucha. My lords, in point 3, I have mentioned that the expression in respect of is used in Constitution in 65 other places apart from Article 1052 and 194. And in PDF pages 24 to 27, I have attached a chart of those articles with the relevant provision. My lords, if the extraordinarily wide meaning is given to the expression in respect of, as per the majority opinion, the same would also apply to other provisions of the Constitution where these words have been used. And according to me, this would result in serious and grave consequences and may lead to incongruous results. Hence, such a wide interpretation should not be given. For example, my lords, I have taken in point 4, under Article 34 of the Constitution, Parliament may by law indemnify any person in the service of the Union in respect of any act done by him in connection with restoration of or maintenance of order in any area where martial law was in force. My lords, if an extremely wide interpretation would have the effect of indemnifying or granting immunity for all acts to that person when done during the martial law was in force, even if the same is not directly related to the restoration or maintenance of order. Similarly, my lord, if Article 122 clause 2 and 212 clause 2 would, if in respect of, would be interpreted in a wider sense, it would mean the immunity can be claimed even in respect of any action taken outside the House, which may relate or concern or have nexus with. So, my lords, my humble submission is that the expression in respect of must be interpreted to mean something that is intimately connected with the subject, immediately followed by the said words in respect of. It means something directly associated with or banded together or closely linked with the subject and not any remote nexus. Therefore, my lords, the majority judgment is in my humble submission in respect of should be limited and should not be given a wide interpretation. Obliged.
Thank you, Gautam. Now, anybody else? Thank you. All of you have formulated it well. All the juniors have really formulated it well. Yes, Mr. Ben.
No.
Has your task become lighter or heavier, Mr. Patel?
Two written submissions. One earlier.
Have they made your task lighter or heavier? Have all the juniors made your task lighter or heavier, Mr. Patel?
And there's a brief note which I had circulated in the morning. Before I take your lordship to that. But Master, today's morning note is
Bye.
it is there.
That's lost.
Before I take your lordships for that, I mean, having been a part of the 239th and 244th Law Commission report, and having partly been author of the report and the concept note written about the importance of looking at criminalization of politics. I am personally estranged from saying anything to the contrary. But apart from that, we are looking at a very, very important consideration of how do we deal with an ancient principle of law, that those who are elected representatives will enjoy certain protection. This principle of law has, if you gather all the constitutions of the world today, they are there in some form or the other, phraseology notwithstanding. That means that this principle is very important for one valid reason, that a person shall be free in the exercise of a function as a member of a legislative body without being impeded by any act of oppression or impairment. Probably those good old days when oppression of the executive was a very important aspect to be looked into. It may also undergo some forms metamorphosis today. The executive cannot be probably directly impair a legislator's function, but it can devise various methods and way of doing this oppression issue as we talk about it. Therefore, if the importance of ensuring that a person elected as a representative shall not be impaired and shall not be exposed to undue exertions or coercions. But at the same time, that the office of high trust being elected to a public office shall not be so exercised as to completely dilute the trust and the importance of the office. Then you're looking at how do you balance them. I don't propose to go into the question as to the minority versus the majority view, because if broadly speaking, all those aspects, in a way, a good part of my thoughts and ideas have been stolen and pirated by all my learned counsel of Arthur William. We can use these very strong expressions. But I'm trying to summarize why are we so concerned about it? It is a concern expressed by each and every one of them in different ways. But if you have to grapple with that concern and produce a norm, we are looking at a court, we're asking the court to produce or generate a norm which can probably interpret and apply in the application of Article 105 and 192. It's not really an interpretation. What we're asking the court is not really an interpretation, something beyond that. A mere interpretation giving meanings like whether the words any or in respect of, by giving such meaning, we are trying to clarify what is important provision of the Constitution intend to convey is one aspect of the matter. But you want to go beyond that and say that the efforts made so far in various jurisdictions, the undertaking, the perspectives, whether in US or in Australia or in Canada. So I've also looked at, for instance, countries like Philippines, Czechoslovakia, and many of the European countries, where there's a report of the European Parliament on this question, the Transparency International, looking at the issue of importance of public life being, on ethical and moral considerations. The same concern runs through all universally in all these places. So if you're talking about not merely an interpretation of any word or an expression in Article 105, but as I said, interpretations are probably not able to go beyond a stage where you keep on repeatedly saying, well, crime is punishable. Guilty outside, but not guilty inside. So if crime is punishable, then why can't it be said so? So if the court had to come and say that 105 does not contemplate, 194 does not contemplate commission of a crime, whether it is connected or in respect of or concerning, then of course the story is complete. So while the majority tried to grapple with this question, I don't think that they were not alive to the importance of reading 105 and 194 very correctly. They were alive to it. But they took a pragmatic view. They look at it from the point of if you have to say something very radical about crimes should be punished, which have nexus or no nexus, it will be punished, then you probably would require to some extent a rewriting of Article 194 and 105 in one sense of the term. Now, if you are looking at actions or proceedings or liabilities which may arise posterior to a conduct or speech or vote in a parliament, that's what on a plain reading of 105 and 194 it seems to protect, posterior to a conduct. And what the minority also tries to say that. So posterior to conduct, there is no difficulty at all. What speeches, what vote was given in the parliament, motives will not be inquired into. So what persuasions went to will not be inquired into. We're talking about something anterior to what happens inside and before the speech or vote is given. Then if that's what we're talking about, and then I am clearly the opinion that anything which is offensive under any law, proscribed by a statute, clearly proscribed by a statute, cannot have a refuge under the Article 105 or 194(2). I'm very clear about that. And I don't think any responsible government or any public authority can take a contrary stand. Let me take your lordships before I go further on this two-page note and then read my earlier written note. I don't think I need to trouble your lordships with the reading and rereading of all the US judgments. Because what emerged in the course of reading those judgments was the distinction drawn between external versus internal activities, legislative versus political activities. So lines are drawn probably to push the protection one way or the other. So what is a non-legislative activity for a person who is elected as a representative? To serve the constituency, you have to do a wide range of things. Brewster talks about it in paragraph 61 or somewhere. So are they protected? Of course, they will be protected as long as there is no criminal or unlawful dimension involved in any one of them. So the entire corpus of US law tries to look at that. But somewhere I find this clear line to be drawn, easy line that can be drawn between external versus internal activities can be somewhere problematic. That I want to flag that. Because in that context, a whole range of work in the parliament depends on an information flow. So one of the cases US was talking about the mail fraud issue, where for the purpose of getting a particular legislation, you work through a criminal process and lobby. In US have a lobbying act. You can pay for lobbying, register yourself as a lobbyist. So we have all that kind of legislative proceedings which have tried to look at this issue from various angles. Therefore, the information flow is required for a legislator to act may sometimes involve getting unwittingly into a crime situation. That can be a trap. That can be something which it does not know. Therefore, these are considerations probably may have to be taken very carefully before the court lays down a very inflexible norm as to whether anything which happens outside the parliament, beyond the speech and vote activity inside the parliament, anything which happens outside, which may have a tinge of or a shade of a criminal activity, will be questionable, could be a little broadly stated. I really want to draw a little concern about that. Not that I want to say that crimes ought not to be, so they can't get the protection of Article 105. I'm not saying that. And then there are, as I said, the political versus legislative activity is also important aspect. We try to draw distinction between political, in the sense, broadly, political propositions outside, political campaigns outside, but they all translate ultimately into a legislative activity. And as one of the Joseph Schumpeter, a noted Austrian economist, who said democracy is all about competition into getting people's minds. So therefore, this political activity of getting into people's minds and then organizing, arranging a whole range of political activity, translating them into legislative process. So that's where the connection sometimes will have to be kept in mind. I thought these are important aspects to be reckoned. And because in one of the earlier cases, I find either in US or somewhere, the question asked is it the protection, is it a special advantage or a special protection? The distinction is very important. You're not asking for a special advantage, but a special protection. So the dimensions of a special protection is therefore seen from all these angles, from all these dimensions. Let me now take your lordship through my brief note, which is in volume 9. Lords have that?
It's not, it's not coming. So
It's just a 2-page note. It's there in the. I have a court master. Yeah. Protection in Article 1052 and Article 194(2) is confined only to the work, because it's in the context of the argument that Sita Soren is relates to a business or work or functions of the House. It's only in that regard. Is confined only to the work, business or functions of the Parliament or the legislature as the case may be. The election to Rajya Sabha is an independent process regulated by a special set of rules and is not a business, work or function of the Parliament. The premises where the election takes place is not determinative of the matter. What is not a function of the business of Parliament or the legislature falls outside Articles 1052 and 194(2). The protection extended in Article 1052 is a part of the larger scheme of protection and immunity to Parliament and its functions. The question is not whether the words in respect of should be narrowly read or expansively read. The view of the majority that the nexus between an antecedent conduct and a speech made or vote given in Parliament would be the reason for extension of the protection under Article 1052 stems from the view that the antecedent conduct, right or wrong, shall not affect or weaken the importance of the protection to speech or vote inside the legislatures. The nexus test thus may have the effect of exclusion from any liability, civil or criminal, regardless of the unlawfulness or otherwise of the conduct, which leads to or is connected to the speech made or vote given. This test requires disregarding the nature of the antecedent conduct. All that 197 CRPC, sanction, etc. The nexus test may not be a safe guide. At the same time, the possibility of any hostile or adverse action being taken on an estimation or perception of the speech or vote should also be kept in mind. The view of the minority that an act that precedes the making of a speech or giving of a vote may not at all qualify a protection, regardless of its connection with speech made or vote given, also deserves to be moderated. On a plain reading of Articles 1052 and 194(2), and keeping in mind the need for freedom of conduct of elected representatives, without being exposed to undue and unreasonable actions and proceedings, it can be said that conduct which is otherwise clearly unlawful and unlawful by reason of being proscribed by a statute will not ordinarily receive the protection against liabilities. However, as a matter of prudence and without sacrificing the importance of high ethical and moral standards in the political field, it will be worthwhile to propose an in-house committee of the respective legislatures to be the speech and vote watch, whose recommendation can be the basis for all liabilities. The 10th schedule to the Constitution of India is a parallel. See, Narasimha Rao is only in the context of a vote given in Parliament. The review by the court be advisedly confined only to the limited aspect and not to any of the larger questions of powers, privileges, and immunities, and perhaps not even to the question of the ambit of speech made in the legislature. But I say this so because the speech legislature can have a variety of dimensions. Whether you take away the antecedent part of it or not, then one has to explain the extent of the speech which requires protection. Therefore, I thought the speech part of it, in the context of the facts of this case, the speech part of it does not arise at all, even though counsel have advised the court on the entirety of the spectrum of vote and speech. So that's I thought will be the narrow ground on which I had under the court. Watch me then therefore take to the earlier written note where I have a few other aspects.
Volume 2, right?
That is in volume 2. Because if 105 and 194 are as an integral part of the Constitution, the Article 14.
Listen, before I forget. Yes.
Good. But I'm not sure whether, if I read it, I just want to, in conclusion with the line of thought which I shared with the Lordship, I'm not sure whether we need to go that far as to look at the basic structure doctrine or on test this on Article 14, etc. Because I think one, the freedom of speech under Article 1051 and 1053, they are the broader aspects of parliamentary, independence and functioning. In that context, 105 is nestled to a different extent. And if that's part of the Constitution, I say it's also part of the basic structure of the Constitution. The freedom of the function of the Parliament, members who elected there, to say that their freedom will be impaired by anything which not dealt with by law, but by any other understanding of the law. I mean, it's going to be a little problematic. Therefore, let us not go to an Article 14 dimension or a basic sector doctrine to look at the relevance or importance of the reading or construction of Article 105. Now, let me complete the reading of this written submission. This is, the first part of it is, of course, confined to the facts of this case, where an argument is that Narasimha Rao would apply, Narasimha Rao need not be revisited. So to just respond to that, I think in my understanding on the facts of this case, where the election to the Council of States happens outside and not a function or a business or the work of the Parliament or the legislature, then Narasimha Rao would not apply. Narasimha Rao is a case where no confidence motion. There's a lot of literature in what exactly the functions of a legislature. Today, it's a wide range of functions. There are even an advisory function. The number of committees that have been constituted with the parliaments across the world, they're truly very exemplary. I mean, you look at the range of functions, Parliament cannot deal with them all over. But the committees are the alter egos of the Parliament, in one sense of the term. Therefore, the question as to what happens as a conduct or a worker of this is also important. So the facts of this case, I think that Narasimha Rao would not apply. And if it does not apply, or the asking of the appellant, perhaps Narasimha Rao to be revisited or not, does not arise. Let me quickly read this part of the written submissions. The appellant has sought the protection of Article 194 of the Constitution as a ground for discharge from the criminal prosecution launched against us. Neither before the Honorable High Court nor before the Honorable Court, any other contention has been raised as relevant for the purpose of discharge. Full reliance is placed on the P.V. Narasimha Rao dicta. Therefore, the short question for the purpose of disposal of the appeal would be as to whether Narasimha Rao would apply at all. The question as to whether the appellant has committed any offence at all, solely with reference to the fact, is not a matter for consideration in these proceedings. The question would be whether the conduct attributed to her does not have the color of an offence by reason of the protective clause of Article 194(2). For that purpose, the only matter to be considered will be whether the exercise of the franchise as an elected member of the state legislature for the purpose of election to the Council of States will be speech and vote within the meaning of Article 194(2). The submission that the invocation of Article 194(2) by the appellant is not a compulsion to wriggle out of an act of bribery can in no way as any submission in relation to invocation of Article 194(2). The distinction sought to be made in paragraphs 1 to 3 of the written submission of Mr. Rajaram Chandran, under the heading "The case at hand" is no distinction at all. The speech and vote immunity is an ancient immunity and has been considered to be a shield against the executive oppression of persecution. The long history of decided cases show the relevance of protecting the speech and vote conduct of the elected representatives from being exposed to civil or criminal action. It is speech and conduct in relation to the manifold functions of the legislature, where the elected representatives participate, that stands protected. In all cases where the elected representative seeks to protect the shelter of Article 194(2), the inquiry will be as to whether the speech and vote is in relation to the manifold functions of the legislature discharged as a legislative assembly. Any conduct other than conduct related to legislative function will thus fall outside Article 194(2). For the purpose of disposal of the case of the appellant, the inquiry as to what is speech and vote in relation to the manifold functions of the legislature need not be taken recourse for the reason that the process of election to the Council of States is like any other election process and cannot be treated as a matter of business or a function of the work of the legislature. Casting a vote for the purpose of election of members to the Council of State is not to be equated to the words vote given in the legislature in any committee thereof. He submitted the Reliance Place and Pashupati Nath Shukul, Mukul Sonso, Kuldeep Nair is in order. The question is not whether parliamentary privilege immunity has been sought or invoked in the said cases. The statement of law that matters of election, either to the Council of State or of Excellency the President or Vice President, are not speech and vote within the scope of Article 1052 and 194(2) will hold good regardless of the context in which the statements have been made. The submission to the contrary in paragraph F, where the appellant, the written submission, is not persuasive. Legislature is a term which is synonymous with legislative assembly, which is a body of persons invested with the power of enacting laws. In the context of parliament, legislature means either house of parliament. In the context of state legislature, it will be comprehend the legislative assembly and the legislative council, as the case may be. The speech and vote expression will therefore relate to the discharge of functions of both the houses. The distinction, if any, between legislature and house of legislature has no bearing on the issue of understanding the speech and vote expression. Whether the governor would be included in the term legislature is no matter relevance for the purpose of delineation of the speech and vote expression. See in this regard so and so. The question again is not one of proceeding on the floor or premises of the House. The question would always be whether the conduct in question is in the context of the business or function of the legislature. All proceeding of all parliamentary committees are recorded the same state of the proceeding in Parliament or state legislature, as the case may be. The question is not the place, the venue of the proceedings of the committees, what qualifies as the respective tasks assigned to the committees and what transpires in the course of deliberation by the committee. It is submitted the conduct of the appellant in relation to the election to the Council of States, not being a conduct relating to the function of the legislature, will not qualify for the protection of Article 194(2). The next part of it generally will address the submissions I made, but quickly I run through them. The subject of privileges and immunities of elected representatives is universally found in constitutional documents. Similarly, despite differences in phraseology, protections are extended to speeches that may be made or votes that may be tendered by elected representatives in relation to the conduct of business or work in the legislative body. It would be a tedious and contentious exposure if elected representatives are to defend themselves in respect of their conduct in relation to the work of business of the legislative body. The logic and the relevance of the protection is well settled. The question of connection and nexus between conduct antecedent to the speech and vote exercised in the legislative body, particularly when the antecedent conduct may be designated as unlawful or proscribed by law, has been a vexed question. Instances of corrupt or undesirable motives behind presentation of private member bills or working in mainstream legislation have received the attention of honorable courts. In this regard, the three articles which give a complete understanding of what the US and is also in European context. I'll just read a few pages of them, but I don't want to travel or through the entirety of the 3 articles. Then paragraph 12, extreme case of submission of bills of expenditure by elected representatives beyond legally sanctioned limits have been found to be beyond the protection of immunities and privileges. Chaitar, so such instances do not present a difficulty in understanding the scope of immunities. Conduct falling in such class being otherwise unlawful and with no connection or relationship with the business, function, or work of the legislative body will fall outside the immunity umbrella. The view taken by the majority in Narasimha Rao is a guarded view. It is not that the Honorable Court lost sight of the shades of the opinion of the Supreme Court of the United States in Johnson and Brewster. The opinions of the minority judges will be considered as coming close to the desirability of looking at high standards of conduct of elected members of legislatures and the need for parliamentary intervention in that regard. A brief glance at deliberations and debates across different jurisdictions and the scope of parliamentary immunity and the incompatibilities of the conduct, which is offensive, undesirable, or unlawful, etc., demonstrate the need for raising the ethical and moral level of conduct of elected representatives. Now, then paragraph 15, the question as to whether Narasimha Rao deserves reconsideration may not hinge only on the majority or the minority understanding of the law. While it is highly desirable that the elected members of the legislatures conduct themselves at the highest level of ethical and moral precepts in order that the values of trust and democracy are not impaired, the question as to laying down norms as guiding criteria would still be, and desirably so, a matter for parliamentary deliberations. While the desirability of delineating and setting down the principles which may govern the scope and application of the speech and vote clause is not to be doubted, the matter of laying down enforceable norms may warrant a wide debate and legislative intervention, including intervention by state legislatures, having regard to the multitude of functions of legislative bodies, which are both directly and through their committee proceeding. In Keshav Singh, all state legislatures and then all high courts were heard. In fact, probably I could have suggested to the Honorable Court to take recourse to that, but now that the court has convened and we have presented arguments, I only say that in the context of these important deliberations, the norm laying down, importance. I'm open to this.
Anything else, Mr.
This is volume A.
Interestingly, Attorney General has suggested a more functional test. He has steered clear of either the nexus test or the essential legislative functions test. Yes. And it's more a functional test. So broadly, what that would mean is that a third test, which would be a functional test, immunity would extend to speech or acts of voting necessary for the discharge of the duties of a member of the legislature without fear of consequences. So it's more functional that you are really having regard to the object and purpose of the grant of that immunity.
Yeah, that's why I thought that the court is not required to go into the second part of Article 1052. For the
Actually, Article 1052, the first part refers to in Parliament. It uses the word in Parliament. So in Parliament would therefore possibly refer to the physical space of Parliament. The latter part is not qualified by in Parliament. So you publish something under the authority of Parliament. You'll publish it outside. Parliament may authorize somebody to publish something outside, but it's protected.
No, even there in that context, whether
because you are publishing a record of what happened in Parliament. Right? That's why the second part says, the second part of 1052 says,
it includes
in respect of any report, paper, votes or proceedings. So report, paper, votes or proceedings is obviously something which took place in Parliament. So though you are publishing it outside, if it's done by or under the authority of Parliament, it's still protected.
It's beyond any question.
Yes, it's protected.
Therefore,
but the first part says in Parliament.
And therefore, its proceedings also in respect of the Parliament or a committee thereof.
In fact, Article 1051 also says in Parliament. It says in Parliament. There shall be freedom of speech
in Parliament. That's a general, the wholesale proposition.
So in the debate
parliamentary independence is doing what it intends to do, and nobody will say from outside, look here, how did you speak in parliament like this?
So if a parliamentarian makes a speech outside parliament, that's not protected. There's no immunity which attaches to that.
No, even the US constitutional law is littered with all those examples of speeches made outside parliament, outside the Congress. But in connection, that's why the question is whether it is a political activity or a legislative activity. So as a, that kind of a dialogue.
In part as such.
No, we're not concerned.
Because that says no person. So obviously person is used in contradistinction to a member of parliament. It will include, of course, a member of parliament also. No person shall be so liable. So liable means liable to a court in any proceeding in respect of the publication by or under the authority of either House of Parliament. So if the publication is done by or under the authority of either House of Parliament.
That's completely protected.
And a publication of what? A publication of a report, paper, votes or proceedings.
260 volume.
Like the searchlight. Transparency.
Thank you. Thank you for your intervention and for assisting us.
Your Lordship, please.
Thank you. Anything else, Mr. Attorney?
I just want to draw attention to a few articles where I thought some reflections seem to be important.
We'll have a look at those articles.
I just give those references.
Two articles which you have referred to.
I just give those references.
Yes. Just give us the
In
page.
volume 4A, I also don't propose to go into the question whether on a proper reading or a correct reading of the Prevention of Corruption Act, this question need not be even gone into, because once they fall under Prevention of Corruption Act, nothing else needs to be, inquired into. I don't propose.
Volume 4A page?
Perhaps that is page 550.
And?
It's an article of the Transparency International, and I just give the few page references. At page 551,
yes,
where they deal with the whole question of narrow versus wide immunity.
551.
And they also give some, illustrations in different countries. 551, 552, 551, 552, 553, then thereafter at 556.
All right. Any other article?
You mean page 1, index.
Would you like us to look at any other articles?
Just.
Yes, sure.
In the same volume,
yes,
a distinction between Britain, Canada, and France. France has a slightly different position, not only non-accountability, but also inviolability. So that's a certain important shade of difference. That you'll also find in page 44.
Same volume.
In the same volume. They're all in the same volume.
Page 44.
Page 44. Then next is an article at page 66 in the same volume.
66.
66. Then page 329.
329.
This takes stock of the law in the European Parliament situation. And at page 161 again, it's a publication by the Directorate General of European Parliament. So they virtually look at the European position in various countries. And one is not surprised to notice that the crime part of
Yes.
elected members. It's not something very peculiar to any particular part of the globe. So these, I thought, would probably throw some light on the generality of these issues. And they submitted to Lordship the question of laying down a norm in reading 194, 105. There had to be.
Thank you, Mr. The SG is going to argue now. Mr. Solicitor, you will.
I'm not going to take more than 20 minutes.
All right, we'll come back at 2 o'clock.
Lord, can your lordship permit me to address virtually, my lord?
Absolutely, yes, no
Right.
difficulty. We are on the hybrid mode. You please feel free, no difficulty at all. So we'll resume at 2 o'clock. And
Yes.
after the learned SG completes, then Mr. Ramchandran, a brief rejoinder from you.
Yes, I'm not going to repeat anything, only one new dimension which may assist you.
But I have one suggestion to the learned AG, that these articles which are mentioned in volume 4A, they don't have the citation. So if you have to cite it, it may be a little
Yes,
difficult.
Mr. Attorney, if you can I just ask a junior after lunch
Yes,
to
yes.
just give us the citation, those 4 articles or 5 articles,
that.
just the citation
We'll do that.
on a separate page of piece of paper. Yes, thank you, Mr. Thank you, Mr. Attorney. Mr. Ramchandran, we'll hear Mr. Ramchandran now and rejoin there. Oh, solicitor. Oh, so sorry. Solicitor has to argue. Mr. Solicitor?
Yes, my lords. My lord, I'm extremely sorry once again, my lord, I'm unable to join physically, which I should have, my lord, but I'm still under the bout of some viral, my lord.
Oh.
That's the reason. Otherwise, my lord, I would have been physically before your lordships, but my coming there would be harmful, my lord, to others.
Yes,
But
yes,
but please come to page 3. My lord, I'm not repeating anything.
Page 3 of your written submission.
My written submissions, your lordships would find at volume 6. I'm sorry, volume 2B. This can be perhaps one more angle from which, my lord, your lordships can consider the question whether bribery can at all be protected by the immunity or the privilege.
Yes.
And
You are referring to page 3, right? Para 5, Mr.
yes,
Solicitor?
yes. Because, my lord, neither the majority nor the minority in Narasimha Rao examines the issue from this point of view.
All right. Let's see para 5 onwards. Let's see how you have formulated it.
My lord, I have formulated para 5. It is submitted that the real issue is not the contours of legislative privilege in relation to the parliament or the state legislatures. Rather, the short question on which the present reference can be decided is whether the offense of bribery is complete outside the legislative house. If it is complete outside the house, then your lordships need not be bothered by us as to whether they would be protected, immunity would stand extended, privilege would be granted, etc. Please see, my lord.
Actually, the place, Mr. Solicitor, the place where it is completed, or whether it is antecedent or subsequent to the speech or vote, really should not matter in that sense, because then it will be a fortuitous circumstance. So suppose we'll just give you a hypothetical example. Suppose the agreement to pay a bribe is arrived at within the house itself, may not be beyond the realm of possibility. That then agreement to pay the bribe is the offer and the acceptance takes place within the house. Maybe when some third party is visiting the house for a committee meeting. We are just giving you hypothetical possibilities.
Correct.
That's the argument. It makes no difference. So it would not really, in that sense, it should make no difference to the final argument or the legal position in that sense.
No, there is a reason why, my lord, I would.
Of course, bribery, you're right. This is on a very, very strong footing that, well, the offense of bribery is complete outside the house, you say.
Yes, my lord. But there is a reason why I am reading the provisions of section 7 which existed when Narasimha Rao judgment was decided. The reason is in 2018, section 7 came to be amended. The argument in Narasimha Rao is that the performance of the promise for which you took the money would be a relevant guiding principle.
Right.
Whether you voted in favor, whether you voted against it, etc., etc. Lord, if that is the logic, which according to me is a flawed logic, then that gets further, my lord, substantiated. My submission is substantiated by the amended provision, but before that, I may show the.
No, fair enough. I now got it. Let's see para 5 onwards. We can first read your formulation and then you can maybe explain it to us.
Please, Your Lordship. Para 6. The privilege in terms of Article 105(2) and 194(2) of the Constitution attaches to anything said or any vote given by a member in Parliament or the state legislature, as the case may be. If on a reading of section 7, the offence thereunder can be said to be complete, independent of and without a reference to anything said or any vote given in Parliament or the state legislature, no question of any legislative privilege being attracted can arise if the member is prosecuted for taking a bribe for the speech or the vote. Now, please see, my lord, section 7, which existed at the time of the judgment. Public servant taking gratification other than legal remuneration in respect of an official act. Whoever, being or expecting to be a public servant, I'm just giving a hypothetical example. I'm contesting the election and I'm promising that if I become an MP, I'll do something for you. Expecting to be a public servant, then accepts or obtains or agrees to accept or attempts to obtain. Now from whom? Any person. For whom? For himself or for any other person. What? Any gratification whatsoever, whatever, other than legal remuneration. Then for what? As a motive or reward for doing or forbearing to do, either to vote or abstain from voting, either to vote in favor, vote against, or abstain from voting. Any official act or for showing or forbearing to show in the exercise of his official functions favor or disfavor to any person for rendering or attempting to render any service or disservice to any person with the central government. Please note this, or any state government or parliament or the legislature of the state. Lord, the legislature, while formulating section 7, was conscious or at least presumed to be conscious of the provisions contained in section 105 and 194.
Yes.
And therefore specifically makes a reference to parliament or legislative assembly while defining and providing for the punishment for bribery. Lord, perhaps maybe this is a little, it can be said to be a little far-fetched, but Lord, is it not, Lord, I'm posing a question to myself, a manifestation of Article 194.3? 194.3 says that the Parliament can legislate as to what would be excluded from the immunities or privileges. So by incorporating Parliament and legislature in the definition of the Prevention of Corruption Act itself,
Yes.
now, second ingredients, which is quite startling. Your lordships are aware, but at more than one places, the majority in PV Narasimha Rao case holds that everything would depend what you do out after you go inside the hall of parliament or within the parliament, whether you vote, you do not vote, you vote as per the promise given, etc. Here, performance of that motive or reward for which you were paid bribe is not an ingredient at all. The moment I accept or agrees to accept or attempts to accept or obtain, the crime is complete.
Yes.
So performance, my lord, which is an underlying ratio in the senior, my lord, in majority view in PV Narasimha Rao case, is absent.
Yes.
My lord, similarly, at page 4, Lord, I have placed for your lordship's consideration section 13 as it existed then. Again, performance, what you do, is irrelevant. Your lordships are right, but in many cases, it is quite possible that the agreement takes place within the house. But in extraordinary cases, even the acceptance of money also can take place inside the house. But your lordships would not, my lord, interpret the provision based upon
the place at which the bribe is given.
Yes, and some extraordinary circumstances. Suppose one MP hands over a bag containing 2 crores to another MP inside the hall, that you vote up in a particular way. Quite possible, but it is one out of 1,000 possibility. Generally, we go by the Prevention of Corruption Act, the way in which bribery takes place. So your lordship's interpretation may perhaps not be guided
Yes.
by extreme examples.
Yes.
Now, if your lordships can ignore, my lord, there are some judgments, my lord, which analyzes these provisions. But please directly come to the amended part. My lord, thereafter, I have quoted the minority view of my Lord Justice S.C. Agarwal. Your lordships have been taken through this, my lord. I don't think I would be justified in reiterating or reading, my lord, the whole thing. Your lordships may kindly directly come to para 16. Now, this is amended section 7. I'm sorry, page 16. This is amended section 7, where the performance, which is not the underlying ratio in the majority judgment, is specifically excluded. But does your lordships, my lords, have section 7?
Yes, sir.
This is section 7 of 2018 amendment. Please read, my lord. Any public servant who obtains or accepts or attempts to obtain from any person an undue advantage with the intention to perform or cause performance of public duty improperly, his intention, not that he will perform, but it becomes further clear. When I pay the bribe, my intention is that somebody would either perform something or will not perform something. Improperly or dishonestly, or to forbear or cause forbearance to perform such duty, either by himself or by another public servant, or it is disjunctive, or obtains or accepts or attempts to obtain an undue advantage from any person as a reward for the improper or dishonest performance of a public duty, or for forbearing to perform such duty, either by himself or another public servant. So my expectation is that you will perform or not perform. But for the purpose of completing the offense, that performance is not necessary. That is becoming clear in explanation 1. But before that, I must read C. So after two disjunctive expressions or, please see C, performs or induces another public servant to perform improperly or dishonestly a public duty or to forbear performance of such duty in anticipation of or in consequence of accepting an undue advantage from any person. These are 3 separate categories of offenses.
Yes.
Now, my lord, it is made exceptionally clear in the explanation 1, immediately, my lord, following subsection 6, C. Explanation 1. For the purpose of this section, obtaining, accepting, or the attempting to obtain an undue advantage shall itself constitute an offense, even if the performance of a public duty by public servant is not or has not been improper. Suppose he goes inside and discharges his duties properly, but he accepts the money. But my respectful submission is that the connection essentially, my lord, established in majority view of Narasimha Rao as to how you perform your part of the bargain is irrelevant for the offense of bribery.
The majority does not specifically dwell on this at all.
It does not refer to at all.
Actually, it was the minority. Justice Agarwal says that, well, the offense of bribery is complete the moment that there is an agreement.
So that's not the correct view, but this is completely what happens is the majority says
Did not deal with it at all.
at all.
Or did the majority say that unless there is performance, there is no bribery? They don't say to the contrary also.
Yes, but when they say that unless there is performance, there is no bribery.
Right. That's how they, all right.
May perhaps run contrary to the act itself. That's the respect.
All right.
My lord, para 15 on the page 70. My lord, that's exactly what your lordships, my lord, hinted. My lord, interestingly, on the aspect of the offence of bribery being complete outside the legislative house or parliament itself, even the majority view holds the same. The majority view, to the extent it holds that prosecution against Sri so-and-so would continue, thus on the sole understanding that the offence of bribery was complete outside the house itself and does not require a vote in the house. Then, Lord, I may not read, your lordships have read and reread the provisions. I'm just not taking your lordships through what we could find out to assist your lordships. I'm not reading it, my lord, because now the way, my lord, in which even the petitioners have argued, so this may not have any direct relationship, because it's nobody's case that there need not be a privilege or immunity. Everyone says that there has to be. The only question is whether bribery can ever be protected under the privilege or immunity. My lord, nature of parliamentary privilege, your lordships, my lords, are aware. I am not, my lord, reading it. I have, my lord, quoted several authors, etc. Then page 21, need for the privilege. Your lordships are aware, my lord, to ensure that I vote, I exercise my rights and perform my duties freely and fearlessly. That's, my lord, in one line, the object of the privilege. Then your lordships may directly come to the position in India at page 24 at the foot. I am not reading it, my lord. We have gathered, my lord, various provisions, and my lord, for example, page 26, Government of India Act 1935 had similar provision for immunity and privileges. My lord, that was section 28 of the Government of India Act. Substantially, my lord, that is adopted in the Constitution. But I am not reading it, my lord. Then your lordships may kindly come to page 29, case law on privilege. But whatever judgments are delivered so far, to our knowledge, there may be few which we may have missed, are quoted, relevant provision is quoted. If your lordships would like to go through them. Then, page 33 is position across the world. We have try and call out, the position across the world. Again, my lord, for this limited questions which your lordships are examining, my lord, this may perhaps not be relevant except, my lord, some academic interest. Then, my lord, 37 is Chetan. My lord, this is the judgment, my lord, I would respectfully rely upon. But, my lord, I'm told this is also, my lord, read before your lordships. Do I not read it, my lord, or I may not trouble your lordships? But I think I should not trouble your lordships.
Which one were you saying, Mr.?
My lord, page 37.
37.
R versus Chetan.
Later, I think we have looked at, yes.
The lordships have, my lord, seen that. So I have just quoted the relevant paragraphs for ready reference. But I don't think, my lord, but my lord, at the foot of page 39, there is one paragraph 246. Now, this is the concurring view in Chetan.
Yes.
And 73, not 246, 73. A little later, the report considers the dividing line between matters that fall within the type of parliamentary privilege and those which fall outside it. This lies at the heart of these appeals and merits quotation in full. This quotation is the concurring view in Chetan. Takes the same view, but in a different phraseology and different language. But that also, my lord, your lordships are taken through. But there is no much development in America after the Sima Rao judgment. That's what we found, subject to the other side pointing out anything new. There is virtually none. Then, page 42, voting or speech in parliament is the core parliament activity. Your lordships are aware, my lord, may not be a matter of contention. Nobody would dispute this proposition, but the judgments, including Raja Rampal, I have quoted, But my lord, as your lordships have very rightly and kindly pointed out that your lordships are not going to revisit that, my lord. Therefore, I am not troubling your lordships. Then page 45. But this, my lord, as a proposition of law, my lord, would be very, very relevant because self-regulation is essential ingredient of separation of powers. All the three. Basically, your lordships are aware, parliamentary privilege is essentially against the crown, against the executive. But the law which has developed or evolved is that all three organs of the state would have the right and power of exclusive self-regulation without any interference by the other. In other words, my lord, the independence of self-regulatory power of parliament is as sacrosanct as, my lord, independence of judiciary or independence of executive. But that's the, my lord, judgment on this. Then, my lord, page 46, examples of exercise of power by parliament itself. Now, this may be of some interest to your lordships. Of course, this may not assist your lordships in arriving at any conclusion on the question on hand. But whatever examples we could find out in India, that how this power of self-regulation is utilized by our parliament. So those examples are cited right from my lord Mudgal case. Mudgal case, my lord, then cash for votes case, where my lord, some MPs came and threw some bundles of money, etc., etc. But I am not taking a loss because this is more, my lord, for my lord, some other, my lord, academic interests rather than assisting your lordships. Then, my lord, again, I am emphasizing privilege as a concomitant of separation of powers, but your lordships are not examining the concept of privilege as such. And therefore, my lord, I am not reading any of these judgments, my lord. Then, my lord, development of the law on privileges again from the narrow compass of bribery vis-a-vis privilege, my lord, may not have much assistance. But since your lordship said that whatever research you have done, please place it so that your lordships gets everything on one page. But that's what we have done.
Yes.
So this is my respectful submission, my lord, that bribery can never be a subject matter of immunity. Unless, of course, my lord, if 1 out of 1,000 cases, my lord, takes place within the house. But my lord, this is not examined. This angle is not examined either by majority or minority. So, my lord, this is, my lord, just for your lordship's kind consideration. Instead of, my lord, declaring Narasimha Rao to be not a good law, the lordships may have an option of saying that it is per incurium because it does not take into account the statutory scheme of the prevention of corruption.
Yes.
Their performance is irrelevant and the offense, which encompasses all its ingredients, does not include performance. And when everything is outside the house and the offense is complete outside the house, there is no question of privilege being claimed or immunity being established as a defense.
Yes.
So these are my respectful submissions.
Thank you, Mr. Solicitor. Thank you.
My apologies, my lord, and grateful my lords permitted me virtually.
Thank you, Mr. Solicitor. Yes, Mr. Ramchandran.
Yes, once briefly, please. Firstly, minutes, apropos an observation from the bench about not speaking, not voting. I respectfully, minutes, bow down to that observation and respectfully agree, minutes, that the immunity must extend not just to speaking and voting, but also remaining silent and abstention And in this context, kindly bear in mind, bullets, that when you are voting on the floor of the house in a modern house, bullets, there is an I button, there is a no button, and there is an abstention button. So an abstention is also a vote given. And the significance of an abstention also, whether it is in the matter of a vote of no confidence on which the survival or otherwise of a government depends, or in the only known case in our constitutional history, Milords, of impeachment of a judge of this court. It's the abstention which made the difference, Milords. And there, of course, it was a whip of the ruling party. So the ruling party en bloc abstained. But in a given case, an individual abstention or 2 or 3 abstentions could make the difference, Milords. And so, if such abstention is also made culpable, it would definitely be in respect of a vote given. And therefore, Milords, by respectful concurrence, Milords, with the observation which came from the bench, Milords.
Yes.
Now, Milords, as far as the learned Attorney General's submission is concerned, he says, Milords, that the judgment in Narasimha Rao's case, the majority, takes a guarded view. I haven't understood the attorney's submission as saying that the majority is wrong. I understood him, and that is why, Milords, I took the precaution in my main argument of addressing his argument on why Narasimha Rao is not attracted. The Attorney General's argument is only this, that voting is not legislative. And I would reiterate, it is legislative for an additional reason which I am going to give, Milords. But otherwise, the Attorney General seems to be ad idem with our submission that the guarded view in Narasimha Rao deserves to be preserved. The Solicitor General's argument, Milords, is concentrated on the offense of bribery being complete. And that is the argument, Milords, of the learned amicus and the interveners led by Mr. Shankar Narayanan. Now, Milords, that argument begs the question of what does in respect of mean. Yes, there can be no doubt that the offense of bribery has been committed at an anterior point of time. But if it is in contemplation of the vote, notwithstanding the criminality, the link with the future vote brings it within the umbrella of privilege. Notwithstanding the anterior criminality.
Yes.
Today, Milords, 2 of the learned counsel for the interveners, Mr. Shankar Narayan and Mr. Hansaria, made a reference to hate speech in the context of the recent hate speech. Now, Milords, I am fortified in my argument by that example for the reason, Milords,
Hate speech.
Yeah, I'll come. Let us take that hate speech example, Bullets.
Mr. Ramchandran, if the ingredients of the offense,
Lordship, please.
the citus of the ingredients of the offense is in the speech itself, then it is immune. Then the immunity is attracted. We are not on the morality of it or whether it is proper or improper. But if the offense lies in the speech itself.
If it was only in the speech, yes. But
now, suppose you are right now you are in you are on your legs. You say something about your opponent, or you say something about a community. All right, that speech itself is the offense. That is immune. That the speaker of that speech is therefore clearly immune because that is a matter of privilege.
Absolutely, but I'm not on
You
the
are now saying
citus.
that irrespective of the if the antecedent criminality if the vote is a consequence of the antecedent criminality, then that itself also is within the ambit of
Lordship,
the
please.
privileges
And
and
for
immunities.
that, Bullets, I didn't complete that hate speech example. Of course, Bullets, if the citus is the hate speech itself, but there can be an anterior event even in respect of a hate speech. A hate speech need not be necessarily a spontaneous speech on the floor of the House. There can be an example of a
There may be a bribe
pre-planned.
in consideration of a hate speech which is made on the floor of the House.
There can be a pre-planned conspiracy. There can be a pre-planned conspiracy.
But then the prosecution is not for the hate speech, but for the bribery, which was the underlying feature of the hate speech.
I am on the offense of conspiracy, which is an offense by itself. It's a conspiracy to commit a crime. Now, therefore, if MP X 5 days prior to the sitting of Parliament has a meeting in his constituency with 3 or 4 of his constituents, that let us put these people in their place. I'm going to say this, and I'll say it in Parliament. Let's see what happens. Nobody can do anything. And as in pursuance of such a conspiracy between an MP and his constituents, it is decided to therefore make that speech on that occasion because of the immunity. The offense of conspiracy is complete 5 days earlier because they have conspired to commit a crime. Therefore, how far do we then go in attaching criminality? And Bullets, the submission which I made, which I reiterate now in this context, is that you can't, Bullets, bifurcate criminal offenses and say we are talking only of bribery, don't touch anything else. Bribery, no, it is not just bribery which has an antecedent element because the physical act has taken place before. Any other criminal act can have an antecedent element.
If the act in this
That's the proviso to 128.
Yes, Bullets. It's section of IPC. Lordship, please, Lordship. Or, as Justice Narasimha Millards just observed, Millards, defamation. So, someone's character is to be besmirched. So you agree among yourselves that I'll say it in Parliament. What is 120A, Millards? Let's see the definition, Millards, of criminal conspiracy. When two or more persons agree to do or cause to be done, one, an illegal act. So let us take 153A, enmity between different groups. So
Ramchandran,
an MP and
you are trying to read something into this provision which we don't find it there under. Scope is totally different. That is what we are trying to tell you.
with respect, no, Millards.
105, it deals with a right of a member to have his freedom of expression, speech, and to vote.
Lordship, please.
That right is recognized, number one. We recognize as the right if he exercises his right by way of speech, by way of voting. The consequence also protected. While doing that, the parliament has got its own privilege, how to deal with it. Like we can expunge it, or we can
Expel the
he
member.
can do say expel him, or if the vote is invalid, it can do that. Now, where is the question of criminality coming here? That is it.
No.
The protection is very limited. What is happening within the house? We are trying to make it much more wider, which is not even under the provision.
Millards,
See,
by
now the privilege and this has been given to maintain the sanctity of the house. All right, anything has happened here, please don't take it out to the street. Nobody else should be able to deal with it. Now, what is happening otherwise? What way, see, we are not able to decipher anything under the provision, whichever way you like to read it. Whatever the interpretation you give, let us give a simple interpretation. What is the objective behind this?
and
Nothing
therefore,
beyond that.
therefore, Millards, my submission is that we are going away from that simple interpretation if we try to say that bribery is anterior, offense is committed, and for that I am drawing an analogy with this, that if you conspire to defame, if you conspire to commit hate speech, which is anterior, and then go and commit it in the house, then by that
But
logic,
if the defamation which is to take place is on the floor of the house,
Lordship, please.
then the act of defamation itself is immune from any prosecution.
Lordship, please.
In such a situation, can the conspiracy itself become actionable under 120A?
Because 120A, let us see. So let us see the definition. Let us see the definition first. When two or more persons, agreement,
Agreed.
Just agreement.
It just says agreement.
Just
But agree to do,
120A is agreement.
agreement.
but agree to do what? An
Let-
illegal act? Now, if the agreement is to make a speech in parliament or the state legislature, which is going to be allegedly defamatory, that act itself is not illegal because that act is completely within the scope of the immunity. The speech itself is protected.
No, I'm sorry. Can I just read out the ingredients of the section and Millards respond to my Lord the Chief Justice? When two or more persons agree to do or cause to be done an illegal act.
Here. The essence, the essence or the element, the critical element is the agreement. Once there's an agreement, that itself, the offense is complete. But the agreement constitutes an offense if what is intended to be done is an illegal act, or an act which is not illegal by illegal means.
Lordship, please, Millards.
So if the act which you are going to, 2 people sit in the house of a member of parliament, or 5 people sit in the house of a member of parliament and say on this day, at this point, he or she is going to make a statement which is defamatory. If that statement itself is not defamatory, or if it is defamatory, it is within the protection of Article 105, then clearly it's not a conspiracy within the meaning of 120A then.
But on the other hand, those who entered into that conspiracy with him, first the conspiracy is hatched consciously to go and make that speech. So on the one hand is the defamation contained in the speech, but anterior to that is the conspiracy to commit defamation
But it's
or
the
hate speech under
But there is
150A.
no conspiracy to commit a defamation because there is no defamation on the floor of the house.
I'm sorry, Mirs. The conspiracy is to
You
defame.
are saying that the conspiracy is independent of
Lordship,
the
please.
actual act, the actual serious.
Lordship, please. The conspiracy is to defame individual X. The conspiracy is to
Anyway,
make
we are
a
really on
hate speech.
hypothetical. We are really on a hypothetical, but I'm not sure you are entirely right on the interpretation because if the act itself is not illegal, there cannot be a
My
conspiracy.
submission is the act is illegal if you conspire to make a hate speech or to defame and then go ahead and do it.
Mr. Ramchandran.
And that hypothetical example has to be given because now we are trying to stretch this to the fact that bribery is anterior. Therefore, it is necessary, Millards, to illustrate the fallacy of that approach by giving this contrary example.
It would depend on the nature of the offense.
Lordship.
So far as, I'm not expert in criminal law, but my friend, so far as conspiracy 120A is concerned, agreement which is illegal itself is sufficient as a crime.
Lordship, please.
Nothing more need to be. 120, there are judgments saying that. So therefore, prior to the participation in the parliament, if an offense prescribed is complete at that point of time, then you can be prosecuted. On the other hand, take the example of defamation. Defamation is complete on the happening, the effect of it on the reputation of the person. Though there is a conspiracy prior to the proceedings of the house, eventually the offense comes into place only upon the utterance in the parliament and the effect of the utterance of the people. There in that cases, then the immunity perhaps attached. But in 120 case, 120A that you are talking about, the offense is complete in the type of a conspiracy before the proceedings have commenced.
In other words, the house is not concerned with the conspiracy per se. It's concerned with the effect of the conspiracy, and that will take care of the decision to be made. When it comes to conspiracy, if it constitutes a criminal offense, then the law will be set in motion. So the house is concerned with that offending part of the speech or the vote, and the resultant action to be taken by it. Only to that extent it will take note of the conspiracy. To that extent it will find fault with the speech made or the voting made. Only for arriving at its own conclusion. That will not take away the role of the prosecution agency in a case where a criminal an offense is made out. 105 is not meant to be protected as such a contingency. The idea is to maintain the sanctity of the house. We can't stretch it too far to say that what has happened earlier, if even assuming a offense is made out, then you should not, immunity will apply. Conspiracy is
Lordship.
punishable in itself, correct?
That if the offense of bribery is in contemplation of a vote to be given in the house or cast in the house, this brings it within the
Protective
ambit, the protective ambit of privileges and immunities, notwithstanding the anterior criminal.
Lordship, please.
That's your
Lordship,
that's the formulation.
Lordship, please. Now, Millards. And therefore, also my submission, Millards, which is part of this, that you can't therefore make a distinction between different types of criminal offenses because always conspiracy, abetment, etc. are also part are also offenses. And therefore, we can't say we are only looking at bribery because it's shocking our conscience. We can't compartmentalize it. Anything which is criminal is criminal. That's how we have to view it, Millers. An attempt was made to remove defamation from the criminal law.
To Parliament.
Wait. Exactly. Lordship, please.
That part of
Yes,
the
but
majority
that
judgment is to be diluted.
That doesn't affect, because it doesn't affect
Therefore,
my
this
case.
first proposition you're giving up there, because we need to dilute the majority judgment.
Because the first
At
proposition
least on
is
that count.
the first proposition is in the context of my submission of relating to the facts of my case, because a vote
But on
was
this
given.
count, it needs to be diluted. That because the majority
Whether
judgment turned on
Ajit
that.
Singh,
Speech made, not made.
Lordship, please, Lord. So,
Ajit Singh is let off because there was no speech made.
Lordship, please, Lord. So I am
That
happy.
logic would have to go now.
I am happy if Ajit Singh had also got the protection, Lords. To that extent. By my agreeing,
To that extent, the
by
judgment
agreeing,
also needs to
I'm
be
only
modified.
happy with that the late Ajit Singh. I
To
wish
that
the late
extent, the
Ajit Singh had
judgment
got
needs to be
protection.
modified, Mr. Ramchandran.
What happened to
To
Mr.
that
Ajit?
extent, it needs to be modified. The judgment needs to be modified.
please.
That
Lordship.
logic would have to go.
Lordship, please.
So
Lord.
your first proposition goes.
I still don't concede that my first proposition goes. My first proposition may be refined. My first
That needs to
proposition
be done.
may be refined.
Your first proposition needs to be diluted.
What happened
Needs to be
Ajit?
refined. Needs to be nuanced. Needs to be nuanced.
By the way, does anybody know what happened to that prosecution of Mr. Ajit Singh thereafter? What happened actually, in fact?
Those are only for.
bribe givers were all
boils
acquitted.
down only to academic discussions in the court. In reality, what happens, God only knows.
As far as
The bribe givers were acquitted.
Bribe givers were
Were acquitted.
Oh.
Because the
Lawyers have the last laugh.
Yes, but- or the Jain Hawala case, Milords, ultimately what happened to the prosecutions.
Exactly.
But there is no escape from PC Act, Ramchandran.
Now, Milords, my second point, I'm making basically 3 points in my rejoinder, Milords. My second point is with regard to Parliament and House of Parliament, Legislature and House of Legislature. Because my Lord, the Chief Justice today emphasized a different aspect of it. Because 1052, as I had also pointed out in my submission, uses legislature in the first limb and House of Legislature in the second limb.
So what is the second submission?
My submission is that the significance of this distinction is not only what my Lord the Chief Justice emphasized in his observations earlier in the day, that House of Legislature authority pertains to what is published outside. That was the emphasis which my Lord the Chief Justice laid. But this distinction is also important in the context of my submission that voting as a member of the legislature for the Rajya Sabha election is a vote given in the legislature, though it is not in the house of the legislature. And let us not, Millards, and therefore, Millards, the submission of the learned Attorney General is misplaced when he, with respect, contends that this is not the kind of vote which is protected under the immunity. I pointed out Article 80 of the Constitution. As an MLA, it is my constitutional duty to vote. It's an integral part of my duty as an MLA to vote. And let us not look at this only from the point of view of an election of an MP or two to the Rajya Sabha. Voting in the legislature and in Parliament, as against in the House of Parliament, also happens in the presidential and vice presidential election. That is also not done in the chamber. It's done in the lobbies, Millards. And your Lordship will recall, in 1969, a president of India was elected as a result of a conscience vote, where, Millards, as against the official candidate of a ruling party,
Mr. Giri, V.V. Giri.
Mr. Giri became president.
Neelam Sanjeeva Reddy was the official party.
Was the official candidate. Now, therefore, voting, this vote, whether it was my client Sita Soren's vote for an Rajya Sabha MP X, or whether it was a Congress MP's vote for V.V. Giri or Neelam Sanjeeva Reddy, they are both of the same character. These were votes in Parliament, these were votes in legislature. And Millards, the same protection must arise. My reason for emphasizing the presidential and vice presidential poll is that these are not just stray Rajya Sabha elections.
There is a vote there.
Lordship, please.
It may not be strictly necessary to.
And finally, Millards.
Yes.
Finally, when I contend before your Lordships to take note of the majority's caution that this can be misused that passage in Justice Bharucha's judgment, which I read out, minutes. It is not something alarmist, mere possibility of misuse. Mere possibility of misuse is not something which I appreciate the courts will not countenance because the courts are there to protect. But the possibility of misuse, going back to Blackstone, Blackstone is not quoted by Justice Bharucha, but the same thought is echoed in Justice Bharucha's judgment. Is the very basis of privilege. Misuse of the criminal law, inter alia, apart from other law, is the historical basis of privilege. And therefore, if your lordships keep that in mind, your lordships are not surrendering to the forces of fear, but your lordships are only recognizing the historical and constitutional basis of this particular privilege we are talking about. I'm grateful. Yes.
Thanks.
And as I've already said, we have a strong case on merits for reasons which we have set out in our written submission. Yeah.
Very
Grateful.
But appearance is not for the judgment.
Very good.
Grateful.
Thank you very much for assistance. Thank you, Mr. Attorney.
Deeply
Thank you, Mr.
grateful.
Patwalia.
Very
Dr. Narayan,
For a very pleasant
Ramchandran.
hearing, minutes from.
Thank you very much for assisting us. All the interveners and the juniors also. Thank you very much.
Thanks to the amicus.
And the amicus. Yeah.
Very, very.
Mr. Solicitor also, thank you. Attorney as well. Thank you.
Very great.